Good morning, everybody, and the committee will come to order. My colleagues, we convene this hearing of the Oversight Investigation Subcommittee to examine the recent outbreak of fungal meningitis linked to contaminated products made by the New England Compounding Center, or NECC. I want to extend my deepest condolences to everyone who has lost a loved one in this tragedy. 32 people have died, including 3 within my congressional district, 1 in Marion County. One of the persons lived right up the street from me. And well over 400 people have been sickened, making this one of the worst public health disasters ever caused by a contaminated drug company in this country. After a tragedy like this, the first question we all ask, could this have been prevented? After an examination of documents produced by the Massachusetts Board of Pharmacy and the U.S. Food and Drug Administration, the answer appears to be yes. Before this outbreak, FDA had conducted 3 series of inspections of NECC, each based on a separate set of allegations or events. The Massachusetts Board of Pharmacy's history with NECC is even more extensive, involving at least 12 separate complaints concerning NECC or its pharmacist, Mr. Caden, since NEC opened in 1998. Over the course of these inspections, regulators noted the same kinds of problems at issue in the current outbreak: problems with sterility and violation of its own license. For example, back in 2002, several adverse events were reported to FDA involving patients who had received steroid injections made by the NECC. FDA followed up and inspected the company. Just 6 months after that inspection, patients were again hospitalized after receiving NECC's injections. In what case can only be seen as a warning, just a simple warning of things to come. The patients infected in 2002 displayed meningitis-like symptoms. The product in question was a very same product connected to the current outbreak. In that case, the NECC drug was contaminated with bacteria. After the 2002 meningitis cases, officials from FDA and the State Pharmacy Board met in 2003 to review NECC's conduct. Now, during this meeting, the FDA made a prophetic statement. The FDA stated that there was, quote, the potential for serious public health consequences if NECC's compounding practices, in particular those relating to sterile products, are not improved, end quote. Even though FDA was clearly aware of the risks posed by NECC's compounding practices, the agency was simply slow to act. In fact, it took FDA 4 years after finding problems with the NECC's sterility practices and violations of the Food and Drug and Cosmetic Act to issue a simple warning letter. The company challenged the charges FDA made in 2006 warning letter. It took FDA another 2 years to respond to the company's claims. When FDA finally responded in 2008, 6 years after the agency first inspected the NECC, it directed the company to correct the violations and warned that it would follow up with future inspections. But the FDA never did so. FDA didn't even follow up after the Colorado Board of Pharmacy notified the agency in 2011 that the NECC was again sending its drugs to out-of-state hospitals without first receiving patient prescriptions. FDA didn't even refer this complaint to the Massachusetts Board for follow-up. We are left to wonder what would have happened if FDA had investigated or at least informed the Massachusetts Board of Colorado of this complaint. It is possible that this outbreak very well might have been prevented. My colleagues, we are joined today by Joyce Lovelace, whose husband Eddie passed away in September. Miss Lovelace, we sincerely thank you for sharing your story with us today. I pledge that we will get to the bottom of this so we can ensure that this outbreak, things like this, never, ever occur again. We're also joined by Commissioner Hamburg of the FDA and Commissioner Smith of the Massachusetts Department of Public Health. I'm interested in learning whether they think this outbreak could have been prevented and whether their agencies did enough to stop it. This committee has a long history of conducting bipartisan oversight, and this investigation is no exception. So it's my sincere hope that this hearing will serve as an opportunity to determine the reasons why such a history as this does not repeat itself. And with that, I give the remaining time to Chairman Emeritus Joe Barton.
I think your time's expired, Mr. Chairman.
Okay. Well, then we'll go to the.
If there is time at some point,
I think we'll go to the ranking member, Mr. Gett. Recognized for 4 minutes.
4 minutes. Thank you very much, Mr. Chairman, and I do appreciate you taking the time to have this hearing on the very day that we return from the recess, because this is such an important public health issue, and we are acting in a bipartisan way. I'm also glad about that. The contaminated steroid injections sold by the New England Compounding Company have caused 438 cases of fungal meningitis, spanning 19 states. 32 people have died, and I'm afraid that number could continue to climb. We have 4 witnesses today to help us examine how this could have happened, and I'm very eager to hear from the FDA and the Massachusetts Board of Registration in Pharmacy, the agencies with primary regulatory authority over NECC, just how we got here. I want to hear from Mr. Barry Cadden about how on earth his company could have been so irresponsible, causing the deaths of so many Americans. And I'm looking forward to hearing from Ms. Lovelace, who, as you heard, is the wife of one of the first victims in this tragedy. I want to join with Mr. Stearns, Ms. Lovelace, in expressing my deep, deep sadness for your loss, and I really want to thank you today. It can't be easy. And Congressman Whitfield, thank you so much for accompanying her today. I know this is hard for you, but it's important. Mr. Chairman, the facts that we've uncovered so far in this investigation reveal frightening failures on multiple levels. And this is one of those real cases where there's a lot of blame to go around for a lot of people. Mr. Cadden repeatedly failed to ensure that NECC and its sister companies were following appropriate safety rules and guidelines. Again and again, reports of problems with the facility were brought to the attention of the Massachusetts Board of Registration in Pharmacy, which failed to act. The board was informed of problems via complaints or even from its own inspections in 1999, 2002, 2003, 2004, and even just this past summer. But somehow, NECC was able to keep its license, avoid significant penalties, and continue its operations until its tragedy struck all across the nation. We also need to hear an explanation from the FDA. Just like the Massachusetts Board, FDA inspectors and officials were repeatedly informed of problems at NECC, but the strongest action taken by the FDA was a warning letter sent to the company in 2006, a letter that appeared to have very little effect. The FDA tells us that they were hobbled by questions about whether they had the legal authority to address the problems at the NECC. If this is true, Mr. Chairman, this is a problem that demands this full committee's immediate attention. We need to clarify the Food, Drug, and Cosmetics Act, which apparently limits the FDA's jurisdiction over compounding pharmacies, and we need to make sure that for these large pharmacies like this, that they have the ability to act and to act quickly on behalf of patients. Over 30 people have died from this meningitis outbreak because too many signals about the risk were missed. One of those signals, as the chairman said, came from my home state of Colorado. In 2011, the Colorado State Board of Pharmacy determined that NECC was distributing unlicensed and unregistered drugs in the state and issued a cease and desist order. But this was not all the Colorado officials could do, and it was not enough to stop NEC's action. Colorado officials notified the Massachusetts Board of Pharmacy, and Massachusetts did nothing. The Colorado Board of Pharmacy did the right thing, but the system failed. NECC did not improve its operation, the FDA did not act, and Massachusetts did not act. Now, Mr. Chairman, for a long time, We've all had sort of a Norman Rockwell vision of the pharmacists who manufacture the drugs our families rely on. The kindly old gentleman in the white coat in the back of the store mixing prescriptions for the little child with the illness. Unfortunately, this tragedy makes clear that large corporate compounding pharmacies are operating unchecked by appropriate safeguards, even as American families trust their lives. So we need to work together now, Mr. Chairman, to make sure this crisis is not repeated. And I will yield the remaining of my time to Mr. Markey from Massachusetts.
No, I thank the gentlelady. New England Compounding Center is in my district in Framingham. My deepest condolences go to all victims and their families. NECC was no stranger to federal and state regulators. It had been the subject of eerily similar safety complaints in 1999, 2001, and 2002. Yet in 2002, NECC's owner, Barry Cadden, was appointed to the state's task force charged with developing new regulations for compounding pharmacies. And in June of 2006, the State Board waived sanctions. My report, which I have completed on this issue, shows that even before the current outbreak, there were at least 23 deaths, 86 serious injuries associated with unsafe compounding pharmacy practices. To Jerry Cohen, Melanie Norwood, Joyce Lovelace, I want to commit to you and to all of the victims that I will not stop until we make sure that these industries are safe. I thank you for your courage. We have to make sure that this never happens again. I yield back.
Thank you. The gentleman yields back and recognize the full chair of the committee, the distinguished gentleman from Michigan, Mr. Upton.
Thank you. You know, when we first began this investigation over a month ago, we knew that people were sick, and we knew that people had died and were dying due to contaminated medicine made by the New England Compounding Center. One of my constituents, too, a grandmother from Cass County, lost her life tragically to these contaminated drugs. The loss of innocent lives is tragic enough, but what makes this tragedy worse is the fact that it seems that these deaths and illnesses could have been prevented. The NECC was not unknown to its regulators. It was not operating under the shadow of darkness. The NECC plant is about a 30-minute drive from the FDA's New England District Office, and the FDA and NECC's state regulator, the Massachusetts Board of Pharmacy, had inspected NECC's facilities a number of times since the company opened its doors back in 1998. FDA even issued a warning letter to the NECC in 06, and the Massachusetts Board of Pharmacy entered into a consent agreement with the company that same year. I was stunned and angered to learn that an inspection of the NECC by the FDA and the Massachusetts Board over 10 years ago identified contamination in the very same drug at issue in the current outbreak. The reason for that inspection? Patients had been hospitalized with meningitis-like symptoms. 10 years later, we're in the midst of an unthinkable worst-case scenario. The body count is growing by the day, and hundreds have fallen ill. Inexcusable. Today we're going to hear from the Massachusetts Department of Public Health and the FDA about their history in the NECC and why they treated the company the way that they did. Why did state and federal regulators feel confident that this company could make drugs safely after repeatedly finding that the company's drugs were contaminated back in 2002? After observing multiple violations of the Food and Drug and Cosmetic Act leading up to the FDA's 06 warning letter, why did the agency fail to conduct a single follow-up inspection? The committee expects the cooperation of the FDA, the Massachusetts Board, and the company as we try to uncover the facts as to ensure that this never happens again. 32 innocent Americans have died during this outbreak, and the public deserves to know what went wrong. I thank Dr. Smith, Dr. Hamburg for agreeing to testify today. Massachusetts Board in particular has provided thousands of pages of documents relating to the NECC. Thank you, Dr. Smith, for making yourself and your staff available to the committee. I wish I could say the same about the FDA. Commissioner Hamburg, the FDA still has not provided the key timeline information requested by the committee more than a month ago. The FDA has not provided its communications relating to the NECC. FDA needs to focus on protecting public health by cooperating with its authorizing committee. We're going to insist today on a firm timetable from you as to when you can produce those documents and the rest of the requested information. The sooner that the FDA cooperates, the sooner we can determine what went wrong and what we need to do to fix it so it doesn't happen again. Mrs. Lovelace, our hearts are with you. They really are. We appreciate your testimony during this very, very tough time. And I yield the balance of my time to Mr. Barr.
Thank you, Mr. Chairman. You've heard the old saying, you can bring a horse to water, but you can't make it drink. Well, you can take a regulator to a problem, but you can't make it regulate. And we've got numerous cases in the last 10 to 15 years of state and federal regulators being made aware of problems at this particular company. And they go out and investigate, or they ask for documentation, and then they issue some sort of a general reprimand, or in some cases do nothing at all. It's an absolute tragedy without any question that 32 people have died, and it's very unlikely that that's going to be the end of the end of the death toll. We have got to get our regulatory authority, both at the state and federal level. When you have what appears to be a bad actor like this company, you have got to get the regulators to use the authority the states have given them and the Congress has given them to stop these practices. And if you read the reports of both the majority and the minority staff that's prepared for this hearing, there are repeated instances of where inspectors just walking through could see obviously contamination in the various batches of this particular product. And it's been going on for 10 to 15 years. So I want to thank Chairman Upton and Subcommittee Chairman Stearns and Ranking Member Waxman and DeGette for, on a bipartisan basis, immediately calling for this hearing, immediately asking that the facts be made present. And let's find out what the facts are and then do what's necessary to put a stop to this once and for all. With that, Mr. Chairman, I yield back.
Gentleman yields back. Recognize the ranking member of the full committee, the gentleman from California, Mr. Waxman, for 5 minutes.
Thank you very much, Mr. Chairman. I want to thank you for holding this hearing and working with the Democrats in making this a bipartisan hearing. We are convening amidst an ongoing public health tragedy. The New England Compounding Center shipped across state lines over 17,000 vials of a steroid, an untold number of which were contaminated with a dangerous fungus. These injections have so far killed 32 people, sickened 438 people with meningitis. This is a tragedy that has brought unspeakable devastation to so many families. That's why I'm very grateful, Mrs. Lovelace, for you being here today. It takes a lot of courage to come forward and speak about this, but it's important that you do so. The facts we've learned to date are very, very troubling. First of all, let's not lose sight of the wrongdoer as we go around blaming the regulators. The regulators deserve blame, but the primary blame in my mind is the company. We had to subpoena the former president of the NECC, Barry Cadden, to be here to testify about how this company handled the matter. And what we learned was that even 10 years ago, people who were regulating the company found that there were sloppy practices that could lead to a public health problem. In fact, the FDA 10 years ago knew that there could be a possible meningitis outbreak. And it wasn't corrected by the company. And the company went about its ways, I suppose always telling people that they were going to behave better. They were going to change their ways. Well, that doesn't mean we don't insist our regulators watching out for the public interest. And I'm pleased that both sides of the aisles are talking about the need for regulation. And what we need to do is straighten out who has what responsibility to be sure it's clear. The Massachusetts Board of Registration in Pharmacy and other state regulators and healthcare providers identified the problem at the company. The Massachusetts Board inspected the facility after the outbreak. They found a horrifying list of problems, and it's shameful that those who ran this facility allowed this to happen. The Massachusetts Board had primary jurisdiction. No one questions that. The state had primary jurisdiction to regulate the company. They were informed numerous times of problems. They even did their own investigation identifying serious issues. But the board never took actions tough enough to stop the New England Compounding Center from putting consumers at risk. And finally, we have FDA. FDA was informed of the problems. They conducted investigations. They raised concerns about the NECC. But the most aggressive action the agency took was a warning letter in 2006. That letter and previous attempts by FDA to inspect and review NECC's actions were met with stubborn refusals and a challenge to FDA's authority. Well, the FDA is questioning their authority. Congress acted specifically in 1997 to limit the authority of the FDA. Then there was a Supreme Court case that left the FDA in doubt as to exactly the authority it had left. This tragedy demands action from this Congress. Mr. Markey has a bill that's a good start. I think we want to work during this lame duck session to pass bipartisan legislation that preserves compounding pharmacies' abilities to operate safely in appropriate situations, yet gives FDA the clear and effective authority to prevent compounders from becoming dangerous drug manufacturers like the NECC. Mr. Chairman, I want to yield the balance of my time to Mr. Dinkle.
The gentleman from Michigan is recognized for the balance of time, but with the consent, the unanimous consent that you could have additional 2 minutes, and we have additional 2 speakers that will speak each a minute apiece after you, if that's by unanimous consent accepted.
I'm not about to make difficulty, and I do thank you for the courtesy, Mr. Chairman.
With unanimous consent, so ordered. And the gentleman, distinguished Chairman Emeritus of the full committee under their majority, and the Dean of the House is recognized for 3 minutes.
Mr. Chairman, I thank you for your courtesy. I commend you for holding this hearing, and I'm very pleased with the speed with which the committee has responded. I ask unanimous consent to revise and extend my remarks. And I note that my home state of Michigan leads the country in the number of cases related to this fungal meningitis outbreak, with 129 patients affected and 9 deaths. These individuals and their families deserve answers as to how this was able to occur. We also need to assure our people that the pharmaceuticals that they purchase are safe. It is clear that the New England Compounding Center, which has a long history of sterility issues and significant other problems, was not properly regulated by either federal or state authorities, and that sitting on the border between the two authorities, they were able to disregard their responsibilities and lead us into a bad situation. It's further clear that NECC blatantly chose not to address deficiencies and violations found by FDA and the Massachusetts Board of Pharmacy, and additionally compounded these steroids without patient-specific prescriptions as required by Massachusetts state law. While I recognize that compounding serves an important public health purpose, I am concerned that NECC was operating at such a volume as to be outside what may properly be considered traditionally pharmacy compounding, and may instead be properly classified as a drug manufacturer and engaged in drug manufacturing. Warnings were given on many occasions to all concerned, and we're going to have to see to it that that situation does not again obtain. I would note that we have sort of the classic system of the tragedy of the commons before us, where what belongs to everybody, or more than one, appears to belong to no one, and as a result, neither agency responsible for its actions dealt with the problems. I'm sure this committee hopes and intends to work with all of us together on both sides of the aisle to find out how new FDA authorities can address the issue before us with proper expansions of regulatory authority, and what additional statutory authority may be needed to prevent future outbreaks like the one from which we are now suffering. I am fearful, Mr. Chairman, that this problem is something which will require fairly strong legislation, but I'm satisfied it's fairly easily done. I thank you for your courtesy to me, and I yield back the balance of my time.
I thank the distinguished gentleman, and now recognize the gentleman from Virginia, Mr. Griffith, for 1 minute.
Thank you, Mr. Chairman, and thank you so much for holding this hearing. Like so many others who have spoken, my area in the Roanoke Valley and the New River Valleys of Virginia have been particularly hard hit. We've had 2 fatalities, and I was on the phone this morning with the father of the youngest victim to date in the United States, a young man who just turned 16 when he was stricken down. He has the advantages of age, but they don't know what his end result will be. On the Friday before he was stricken, he caught, as a sophomore, caught 3 interceptions in a football game, ran 1 back for a touchdown. Just a great athlete. This gives him some advantages, but how will his life be changed? We don't know. Our job here is to find out why this happened and then to make sure that it doesn't happen again. And I look forward to working with everyone to make sure that we get to the bottom of this in a bipartisan fashion, and also want to thank Ms. Lovelace for being here today and express sorrow for your loss. With that, Mr. Chairman, I'll yield to Ms. Blackburn.
Gentlelady from Tennessee is recognized for 1 minute.
Thank you, Mr. Chairman. I am appreciative of the work that you and your staff have done and the manner in which we've moved forward so quickly on this issue. And I do want to welcome our witnesses, and Ms. Lovelace, we do welcome you. We're appreciative that you would take your time to join us. According to the CDC, 81 Tennesseans have been affected with fungal meningitis, and 13 Tennesseans have lost their life. This is something that is of tremendous concern to us, and it is because of this, and on behalf of my constituents and those families that have been adversely impacted by this fungal meningitis outbreak, I am interested to hear why the FDA did not pursue any enforcement actions against NECC, despite having emphasized nearly a decade ago, the potential for serious public health consequences. These are answers that we are looking for. They're questions that we have each approached during our comments, and I look forward to the hearing. I yield back.
Gentlelady yields back. We are now ready to have our first panel. Our first panel is Mrs. Joyce Lovelace. She's the wife of the late Honorable Eddie C. Lovelace. Judge Lovelace served as a circuit judge for the 40th Judicial Circuit in Kentucky's Clinton, Cumberland, and Monroe counties. Judge Lovelace was the first confirmed death as a result of fungal contamination from steroid injections. Before Ms. Lovelace begins her testimony, I would like to recognize her congressman, the distinguished gentleman from Kentucky, who's also chairman of the Energy and Power Subcommittee and represents the 1st District of Kentucky, for an introduction of Ms. Lovelace.
Chairman Stearns, thank you very much, and Ranking Member DeGette, and all of the members of this committee. We genuinely appreciate your being here to investigate this very important issue. I feel very fortunate to be here with Joyce Lovelace today, not only because she's a constituent, but because ever since I've been a member of Congress, Joyce and her husband Eddie have been very good friends of mine. They live in Albany, Kentucky. You know, we talk about statistics and figures, and yet when you look at the individual lives involved, it makes all the difference in the world. Joyce and Eddie were married almost 56 years. He died on September the 17th, 2012, as a result of complications from the contaminated steroid injection that caused fungal meningitis, and which is the focus of this hearing. He was 78 years old, but I might say that most people who met him thought he was 50 years old because he walked 3 or 4 miles every day. He was a circuit judge, was one of the leading legal scholars in Kentucky, had also served as a chief prosecutor, a county attorney, and he was one of those people involved in every aspect of the community of Albany. So we will all miss Eddie Lovelace. We'll never forget him. And at this time, I want to thank Joyce very much for being willing to share her story and Eddie's story with the committee. And Joyce, thank you very much for being here with us this morning.
I thank my colleague for that fine introduction. Ms. Lovelace, you're aware that the committee is holding an investigative hearing, and when doing so has had the practice of taking testimony under oath. Do you have any objection to testifying under oath? No. The chair then advises you that under the rules of the House and the rules of the committee, you're entitled to be advised by your counsel. Do you desire to be advised by counsel during your testimony today? Okay. In that case, if you are able to stand, if not, then please raise your right hand and I will swear you in. Do you swear to tell the whole truth, nothing but the truth, so help you God?
I do.
You are now under oath and subject to the penalties set forth in Title 18, Section 1001 of the United States Code. We welcome you today, and you can now give your 5-minute summary opening statement, if you would.
Thank you, Mr. Chairman and members of the committee. I'm very much encouraged by what I have heard from you today, that you do plan to move on this and to investigate this matter. And that is basically what my family and I desire, is to get to the bottom of this and make sure that it never happens to another family, because we have lived a nightmare. We will be living this nightmare for ages to come. It's something that probably we will never really be able to get closure, because it was just such a useless thing that happened to my husband. I don't have any notes. My husband hated notes. Obviously, he can't be here, and I'm here on his behalf. So I'm just speaking from the heart, and I think he would not want me to have notes. He didn't. He never read. He always spoke. I was fortunate enough to have been married to this amazing man for nearly 56 years. And I won't say that it was always pleasant or smooth or anything, and I don't think any marriages are, but we worked together in his office. We were married when he was in law school, and I worked and helped him make his way through law school, and then we moved to Albany and made our home there. And he immediately began to get involved in civic matters, community matters. He taught Sunday school at 42 years and was still teaching when he passed away. He was a gifted speaker. Really, I want these people to know what kind of person that has perished because of their lack of concern. My family is bitter. We are angry. We're heartbroken. We're devastated. And I'm just kind of here begging you to do something about the matter. I cannot say enough good about him. He was bigger than life in any setting that you put him in. And I worked in his office alongside of him, so I have seen all sides and have seen him interact with all classes of people in all situations. And he had a gift of working with people. He was compassionate. He wanted to help the people that needed it. He was always wanting the victim in any situation to be taken care of and given full consideration. And it's ironic that he winds up the victim in this. My family, I can't begin to tell you what I have lost. My soulmate, my partner, words can't describe. Our older children, our older grandchildren, he was their anchor, their rock. They looked to him for advice. He guided the older ones through college and helped them decide what steps or what direction that they wanted to take. Our oldest granddaughter became an attorney. based upon her appreciation, I think, for him and the work that he did. And he had 2 more years left in his term as judge. He planned to complete that term and go in practice with our granddaughter and help her get started. Now, she has no one. Our younger grandchildren have lost the best playmate they ever had. He played anything that our grandchildren asked him. They could dress him up. They could do anything. And he was happy to do it. I mean, they all wanted Pawpaw. Our youngest granddaughter asked him, even when gas prices were so high, and they still are, asked him, "You drive me around, Pops, and let me just read." And he would get her in the car, and he would drive and let her read her books. She's now in the 6th grade, and she's an avid reader. But these are some of the things that we're going to miss. He had a brilliant legal mind. He studied the law. Every weekend on Friday, he wanted all the opinions of the appellate courts printed out, and that was his weekend's reading. He would get kind of miffed at us if we didn't get it done, because that would ruin his weekend. Now, he wasn't a sick individual. He was healthy. He walked 3 miles every morning before I would even get out of the bed. He wanted to stay active. He didn't have the appearance of a 78-year-old man until about the 2nd injection. And then we began to see the difference. Where he had walked those streets every morning, he was stumbling, he was losing his balance, he fell often, he began to have headaches, which he never had before. And I was really concerned by his appearance. He had the look of someone who might have cancer. He had a physical examination just maybe 2 weeks before he fell sick, before he came sick, and they found nothing wrong. The only problems he had were kidney stones and allergies, neither of which I think would have taken his life. On the 11th of September, he began to have numbness in his hand, and we begged him to go to the emergency room, and he declined. That evening, he had a bad headache, and then he told me that 2 fingers on his hand were not right. He couldn't use those 2 fingers. Then it became his fist. He couldn't. But he still would not go to the emergency room. He just was an individual that was not sick that much, and he wasn't going to go to doctors. He just didn't go until he had to. The next morning, of course, he had been up, and when I got up, he was hollering for me in the kitchen. He had a horrible look on his face. I'll never forget that expression. And he said, "My legs don't work." He said, "I've been out twice to get my paper, and I've fallen twice." Our daughter is a nurse, and I called her, and she took him to the emergency room. I believe they did a CT scan there, and it didn't show anything, but based on his symptoms, they transferred him to Vanderbilt in Nashville. To back up, he had had a car accident in March, the last of March, and had injured his lumbar and cervical spine. And he had gone through the physical therapy. He had done everything the doctors had told him to do in an effort to try to get better, to be able to work was number one on his mind, get back on the job. He was transferred, he was referred to a Dr. Abrams, a neurosurgeon at St. Thomas. And that's where he received these injections. at the St. Thomas Neurosurgical Outpatient Center. They admitted him to Vanderbilt on the 12th. He immediately, just within a day or two, started declining fast. I mean, rapidly. His speech became slurred. He lost the use. He had no grip in his left hand. He could not move his left foot. He had no eye-hand coordination. He could not feed himself. It was a nightmare to see this man who was perfectly healthy one moment and then just so quickly going downhill. And everything the doctors were doing for him was to no avail. The medicine, whatever they did, it was not helping him in the least. And he just declined so rapidly that on the 17th, he passed away. And people, it was not an easy death that we witnessed. And these are human beings that these committees, the FDA, the NECC, whoever is responsible, I want them to know their lack of attention to their duties cost my husband his life, cost my family, cost them a loss that we'll never recover from. And if you don't do your job, it may not appear to be anything to you, but you are affecting human lives, valuable human lives. My husband was valuable to us. And I cannot beg you enough. Bipartisan, go, I don't care what party, work together and
we will do.
Legislate this so no other family has to go through what we have.
Ms. Lovelace, thank you very much for your poignant testimony, your statement. I'm just going to ask two questions, short and brief. The first one is, when you found out that your husband was the first of many to be linked to this contaminated products distributed by the NECC, do you remember when that was, how long after he died, and secondly, who was it that informed you about this?
He passed away on September the 17th, and we went ahead with the funeral services and everything, thinking that he had a stroke because that was their diagnosis. On the 3rd of October, I believe it was, we began to hear about the contamination on from these injections.
From the press?
Yes.
Who told?
Through the press.
Yeah.
My son-in-law, I think, was the first that read it or heard it. On October the 5th, I received a call from a reporter from the Nashville Tennessean, and he told me that a spokesperson at Vanderbilt had issued a statement that a 78-year-old man had died from the contaminated steroids.
So the first you heard about it was from the Vanderbilt Hospital?
The first I heard about it was from...
So no one from the FDA or the Center for Disease Control, did they ever contact you?
No. St. Thomas did not contact me.
So we actually heard about it through a press report?
Press.
And no one from the state of Tennessee contacted you?
No.
Did they subsequently, after you heard through the press, did the state of Tennessee or FDA or the Center for Disease and Control?
I got on the internet to try to find out something about it, and I saw a phone number on there, and I called it.
So you initiated it?
Yes.
No one from outside came to you?
No one.
Even after the press reports? And the Vanderbilt Hospital, did the doctor call you?
No, the Vanderbilt didn't know about him having the injection.
Okay. Okay.
It was over at St. Thomas. Now, on the 25th, and bear in mind that his funeral was the 21st, on the 25th, someone from St. Thomas called my cell phone and asked how Mr. Eddie was doing from his procedure. And I was really taken aback because we had just buried him. And I told her so. And, well, she was so sorry what happened. And I said, well, they believe he had a stroke. So then the next day, a different lady from the same place called, wanting to know what his symptoms were, how long he had had the symptoms, and whether or not we had an autopsy performed. And neither person mentioned contamination, meningitis, anything like that.
You know, it's a possibility that what you say is a stroke. There might have been people that had died because of the contamination prior to your husband that were elderly, and they attributed to a stroke. And we'll never know. I think my last concern is the feeling I have that you had no contact with the FDA and these other folks that I mentioned. I think if they did contact you and told you about it, I think what you would say to them is, why didn't you stop it?
Right.
And obviously, if you had to talk to Mr. Cadden, who is the CEO of NECC, you could say, how in the world would you be so oblivious to the lack of quality control and all the notices that you got prior to your manufacturing these large numbers of drugs? So that's the questions I want to ask. I want to thank you again for your courage to come here, and I recognize the ranking member, Mr. Gett from Colorado.
Thank you very much, Mr. Chairman. I just want to follow up, Ms. Lovelace, on some of the things the chairman was saying, because when they went over to inspect NECC, they found vials with little black stuff in them, and they found insects near the areas, and terrible working conditions. And you know, sometimes in this committee we've seen this before with food manufacturers, and we all sit here and we say, how could this happen in the 21st century and the most civilized country in the world? And the reason why it is so important that you came today, and it's so hard for you, I'm sure, is because it's easy for regulators and for Congress people to talk about this in the abstract, and for you being here, there's hundreds of people around the country who have either lost loved ones who were just as cherished to them as your husband was to you, and or they're sick and they're still sick. So I just want to let you know it makes a big difference for you to come here today, and I want to thank you for doing it. It's not easy, I know. And I also want to let you know that with some of the food safety issues that we identified a few years ago, we actually did pass legislation that clarified it. And so as hard as this is, and as senseless and unnecessary as this is, I will guarantee you that I'll be working with Mr. Upton and the entire committee, Democrats and Republicans, to make sure we clarify this. And I think one of the problems, as well as just sloppiness on the part of the Massachusetts Regulatory Agency and the FDA, the other problem was this gray area in the compounding pharmaceutical law, where the FDA wasn't really sure if they had jurisdiction or if they'd be sued in court. We can fix that, and I will guarantee you we will fix that. And when we do fix that, unlike these regulators, we'll call you and let you know. Okay? So thank you very much for coming, and I yield back the balance of my time.
Gentleman yields, yes. We will open the floor for additional questions. Just to remind members, we have the second panel is Barry Cadden, who's the CEO of NECC, as well as we have the third panel. So if anyone would like to ask a question, Mr. Burgess, recognized from Texas.
Thank you, Mr. Chairman. Ms. Lovelace, I do appreciate you being here and sharing your story with us. You made the comment that your husband was important to your family. I'll just stress that he's important to this committee as well. And just like the ranking member, when she was talking about some of the food safety investigation we've done, I mean, your story as you were relating it was just so similar to this very room. Maybe 2 years ago, we heard a similar story about salmonella, and the family actually learned about it, that the loss of their loved one, they learned about it through the newspaper, that maybe it was the tomatoes in the salad or wherever it was, wherever the contaminant was from, and the same things. The place where things were grown, there was obvious areas where there was contamination going on. We've read the memos, and we understand uh, the litany of problems that existed at this manufacturer. Can I just ask you a couple of questions to clarify in my mind the timeline that the clinical course that your husband had? He had the automobile accident, and roughly when was that?
March 30th of this year.
Okay, and then his treatment at the outpatient facility for the steroid injections, he had 2 of those?
3.
3. And so I guess the last one would have occurred when?
August 31st.
And his illness began?
The 11th. Well, it really began before, but it was really magnified on the 11th.
So roughly not quite 2 weeks afterwards. And when he was admitted to the hospital when he was transferred to Vanderbilt, when did that occur?
That was on the 12th, the morning.
So he had a pretty rapid decline in his clinical course. Now, did the doctors know in coming into Vanderbilt that he had the previous outpatient therapy at the other facility?
No, I don't believe he did. Our daughter accompanied him to the hospital, and I don't believe that that was in his history when he was admitted.
And it may not have occurred to anyone to ask, and obviously now in retrospect, this all becomes very intertwined. I mean, this is tough, what you've been through. We don't have an opportunity to talk to them, but I suspect it's tough for the doctors involved as well.
I'm sure
for the doctor who provided the steroid injection, as well as the doctors that were treating, not knowing what they were up against.
I'm amazed that they were ordering medicine from someone that had that reputation.
Well, maybe that's part of our problem, that information may not have gotten to where it needed to get. Well, again, we appreciate your courage and your strength for being here and relating this to us today. It is an important part of this story, and certainly look forward to what we can do for you in the future. Thank you.
Thank you very much.
Anyone else who wishes to ask a question? Anyone on this side? Short question?
Just a short comment here. I thank you for being here because of the statement you made about the importance of the organizations involved that are supposed to be inspecting. Clearly, there's a lot of information that they knew that this compounding pharmacy had problems. And whatever the issue was, as you are keenly aware of, surely you've searched your soul many times. How could someone stop and say, it's not my job, it's not my job description, it doesn't matter? It is so important that you're here, and it is, I'm sure it's difficult, I'm sure it's tragic, but it's still, I thank you for having the energy to be here and help people put a face on this. There is a role of these agencies, and at no time should ever someone say, this is a gray area, I don't want to overstep the boundaries, because the fact that people did that ended up in a tragic loss. So I thank you for having the courage to be here and helping to put a face on this. Thank you.
Gentlemen, and with that, Ms. Lovelace, thank you very much for your testimony, and we thank our colleague, Mr. Whitfield, for his time, too. And with that, we'll call up... With that, we'll call the second panel. Mr. Cadden is asked to come to the desk. Okay. Mr. Cadden, my understanding is that Mr. Cadden authorized his counsel to advise the committee that he will rely on his constitutional right not to testify at today's hearing. I believe that this privilege should be personally exercised before the members, as we have done in the past, and that is why we have requested that he appear today before us. I request that, given the importance of his testimony, he reconsider his decision to invoke his Fifth Amendment rights, especially because the families of the people who have lost their lives after receiving a contaminated injection made by his company, the New England Compounding Center, those who are sick and those who have received injections are waiting to see if they too will get sick. They deserve some answers today. Mr. Cadden, I ask you to reconsider, and tell this committee and the people watching this hearing how this tragedy has happened. Mr. Cadden, are you aware that the subcommittee is holding this investigative hearing, and in doing so, we have the practice of taking testimony under oath?
Make him turn on his microphone.
First of all, Mr. Cadden, you just need a yes or no for this question. Do you have the... Put the microphone on. Put your microphone on. So we're just asking you basically, do you understand we have the practice of taking testimony under oath? You understand that. And do you have any objection to testifying oath?
No.
Okay. Chair also advises you that under the rules of the House and the rules of the committee, you're entitled to be advised by counsel. Do you desire to be advised by counsel during your testimony today?
Yes, I do.
In that case, would you be so kind as to identify your counsel for our record?
Mr. Attorney Bruce Singal and Stephen Ross.
Okay, and where is Stephen Ross? Okay. Mr. Ross, do you want to come and sit in the front here? Okay. At this time, we're going to swear you in. Please raise your right hand. I'll swear you in. Do you swear to tell the whole truth and nothing but the truth, so help you God?
I do.
Thank you, Mr. Cadden. I'll recognize myself for the first part of the question. Mr. Cadden, are you one of the owners of the New England Compounding Center, or NECC, the company that distributed contaminated injectables to medical clinics, doctors' offices, and hospitals across this country?
On advice of counsel, I respectfully decline to answer on the basis of my constitutional rights and privileges, including the Fifth Amendment to the United States Constitution.
Mr. Cadden, 32 people have died. 400 people are infected, and scores of others who were injected with medicine your company compounded are waiting, holding their breath to see if they'll get sick from the products you made. You've been the director of pharmacy at the NECC since it opened. You have responsible for ensuring that the products were safe and sterile. Mr. Cadden, what explanation can you give the families who have lost their loved ones and those who are gravely ill for the actions of your company?
Mr. Chairman, on advice of counsel, I respectfully decline to answer on the basis of my constitutional rights and privileges, including the Fifth Amendment to the United States Constitution.
The Massachusetts Board found that you released 2 lots of the injectable drugs at issue in this meningitis outbreak before you received the lab tests as to whether the drugs were sterile. They also found black particulate matter within the injectables. The FDA found greenish black matter in the vials. Mr. Cadden, there is no question there was a massive failure of sterilization at your facility. For the sake of protecting the public health and preventing something like this from ever happening again, and to provide some explanation to grieving families, can you please tell us what was the breakdown that led to the contamination and the meningitis outbreak?
Mr. Chairman, on the advice of counsel, I respectfully decline to answer on the basis of my constitutional rights and privileges, including the Fifth Amendment to the United States Constitution.
I now recognize the ranking member to get 4 questions.
Cadden, we just heard from Joyce Lovelace. Joyce Lovelace's husband, Eddie, was the first one who was found to have died of fungal meningitis from one of your company's products. He was a judge. He was a husband of 56 years. He was a father, a grandfather. He was getting ready in 2 years to leave the bench so he could go into law practice with his oldest granddaughter. And there are a number of other victims around the country now who have either died or become terribly ill as a result of your product. And the chairman talked about some of the findings that they found just this year in your company, the greenish black foreign matter inside the vials. There were also things like a leaking boiler next to the clean room that created a pool of water, which creates a breeding ground for bacteria, an air conditioning system that turned off at night despite requirements that the clean rooms had a consistent temperature. Your own environmental monitoring program showed violative levels of bacteria and mold in clean rooms between January and September of this year. When FDA inspectors looked at NECC's sister company, Ameridos, they found the same kind of thing. They reported that there were insects in or near areas where sterile products were packaged, stored, and manufactured. They even saw a bird flying inside an area where there are supposed to be sterile packages. So I guess I would ask you, what do you say to all of these patients and all of these families that have been devastated by these contaminated products that your company's produced?
On advice of counsel, I respectfully decline to answer on the basis of my constitutional rights and privileges, including the Fifth Amendment to the United States Constitution.
Mr. Chairman, I think it's clear that the witness does intend to exercise his Fifth Amendment rights. And with that, I think I will not ask any more questions. We won't have any more on this side. Thank you.
I thank the ranking member. Let me be clear, Mr. Cadden. Again, are you refusing to answer the questions on the basis of the protections afforded to you under the Fifth Amendment to the United States Constitution?
On advice of counsel, I respectfully decline to answer on the basis of my constitutional rights and privileges.
Will you invoke your Fifth Amendment rights in response to all questions today?
Yes.
Then you're excused from the witness table at this time, but I advise you that you remain subject to the process of the committee, and that if the committee needs is such, then we shall recall you.
Thank you, Mr. Chairman.
Now my colleagues will call up the third panel. My colleagues, we have on the third panel Commissioner Margaret A. Hamburg. Margaret A. Hamburg became the 21st Commissioner of Food and Drug on May 18, 2009. Prior to assuming her role as Commissioner, Dr. Hamburg was a senior scientist at the Nuclear Threat Initiative. She also served as the Assistant Secretary for Policy and Evaluation in the U.S. Department of Health and Human Services and as Commissioner of the New York City Department of Health and Mental Hygiene. We also have the Interim Commissioner, Lauren A. Smith. Lauren A. Smith has been the Interim Commissioner of the Massachusetts Department of Public Health since October 25, 2012, and prior to assuming that position, Dr. Smith served as a Medical Director and Chief Medical Officer of the department. Let me welcome you to the committee, and let me ask you, you're aware that the committee is holding an investigative hearing, and when doing so has had the practice of taking testimony under oath. Do either one of you have an objection to taking testimony under oath?
No.
No.
The chair then advises you that under the rules of the House and the rules of the committee, you are entitled to be advised by counsel. Do you desire to be advised by counsel during your testimony today?
No.
No.
In that case, you please rise and raise your right hand. I will swear you in. You swear to tell the whole truth and nothing but the truth, so help you God. You are now under oath and subject to the penalties set forth in Title 18, Section 1001 of the United States Code. You may now give a 5-minute summary of your written statement. Dr. Hamburg.
Mr. Chairman and members of the subcommittee, I'm Dr. Margaret Hamburg, Commissioner of the Food and Drug Administration, and I'm joined by Howard Sklamberg, Deputy Associate Commissioner for Regulatory Affairs. Thank you for this opportunity to testify about the tragic fungal meningitis outbreak associated with an injectable steroid product distributed by NECC, as well as safety concerns related to compounding and the legislation that is needed to prevent such incidents from happening again. I want to begin by offering my deepest sympathies to the patients affected by this outbreak and their families. This event has had devastating effects on patients across the country, such as Eddie Lovelace, Judge Lovelace, many of whom were likely unaware that they were being treated with a compounded product not reviewed or approved by the FDA. Our foremost goal is the protection of the health of the public. Since the onset of this outbreak, we've targeted FDA resources from experts in our headquarters to inspectors and scientists in district offices and labs across the country to do everything we can to stem the toll of this terrible event. Together with CDC in the states, we've sought to identify potentially contaminated products and ensure that they're removed from the market and do not reach patients. We've collected and analyzed hundreds of samples from the relevant firms as well as from medical facilities and state and local agencies to isolate the cause and determine the extent of the contamination. We are working daily to ensure timely, clear, and accurate information is disseminated about the findings of our investigation, what products are affected, and what providers should do with any products still on their shelves. And we're working to alleviate existing drug shortages exacerbated by product recalls. We've also been reviewing actions taken in the past with regard to NECC. From our review thus far, we have no reason to believe that any of the specific actions in question, more timely issuance of the 2006 warning letter, or inspectional follow-up, would have prevented this recent tragedy. What we do know is that stronger, clearer authority would enable more effective regulation of the drug compounding industry, especially when it has been evolving so significantly. As it is, our authority over compounding is limited, unclear, and contested. And in the face of differing views in Congress and the courts about FDA's authority and continuing challenges by industry, the agency has struggled with how to chart an effective course to protect the public health. We recognize that traditional compounding provides an important service for patients who, for example, can't swallow a pill or are allergic to an ingredient in a drug product. But the industry has evolved well beyond the neighborhood pharmacist. In particular, the movement by many hospitals to outsource pharmacy compounding has created a market for compounding operations that produce drugs that reach far larger numbers of patients. When these facilities operate well, they may serve an important function in terms of safety and efficiency. However, when they fail to follow safety and quality standards, many patients may be harmed. Our best information is that there are thousands of other compounders out there producing what should be sterile products made to exacting standards, and thus many other firms with the potential to generate a tragedy like this. The current oversight framework in attempting to draw a bright line between compounders and manufacturers fails to address the complex issues raised by a changing industry. Additionally, gaps and ambiguities in the law have hampered our ability to act to protect patients and to prevent rather than just react to safety concerns. I'm committed to working with Congress and other stakeholders to design a system of rational, risk-based regulation that takes into account both the federal and the state roles. As I outlined in my testimony, we've developed a proposed framework that would tier the degree of oversight to the risk posed by the type of product and practices. Traditional compounding would remain the purview of the states. The higher risk posed by non-traditional compounding would be addressed by federal standards, including standards for quality control. And under this framework, certain products carrying the highest risk could not be compounded. They could only be produced by entities willing to meet the standards currently required of drug manufacturers. We would like to explore with you authorities that would be important to support this new regulatory paradigm, including clear authority to access records, mandatory reporting of adverse events, additional registration requirements to facilitate appropriate oversight and coordination with state regulators, clear label statements to allow prescribers and consumers the opportunity to make informed judgments, and adequate funding to support the inspections and other oversight activities outlined in this framework. And because a key piece of any plan involving oversight of pharmacy compounders will continue to be performed at the state level, we must work closely with our state partners as we develop the framework for new authorities. Consequently, FDA will be inviting representatives from all 50 states to participate in a full-day meeting on December 19th to facilitate these important discussions. We have a collective opportunity and responsibility to help prevent future tragedies. If we fail to act, this type of incident will happen again. It is a matter of when, not if. If we fail to act now, it will only be a matter of time until we are all back in this room, sadly, asking why more people have died and what could have been done to prevent it. I'm happy to answer any questions you may have.
Thank you, Dr. Smith, for your summary of your opening statement.
Thank you, Chairman Stearns, Ranking Member Jagat, and members of the committee. Thank you very much for having me here today. My name is Dr. Lauren Smith, and I'm the Interim Commissioner of the Massachusetts Department of Public Health. I have to also begin by saying that my thoughts are with the victims and families affected by this tragic outbreak, and with Mrs. Lovelace, whose moving testimony only strengthens my resolve to ensure that no other family has to suffer what she aptly described as the heartbreak that hers has. As a mother, a pediatrician, and a public health leader, I have devoted my life and career to protecting the health of others. These events evoke in me the same sense of outrage as they do for you and the rest of the public. For many of you, I know this hits very close to home. For the past 2 months, our department, along with the FDA, has conducted a joint investigation of New England Compounding Center, the source of this devastating fungal meningitis outbreak that has sickened hundreds and killed 31 people across the country. We have also investigated and shut down NECC's sister companies. NECC knowingly disregarded sterility tests, prepared medicine in unsanitary conditions, and violated their pharmacy license, endangering thousands of lives as a result. NECC bears the responsibility for the harm that they have caused with these actions. I was given the responsibility as interim commissioner less than 3 weeks ago to lead my department through this crisis. And like you, I have been trying to put together the pieces of the puzzle. First licensed by Massachusetts in 1998, NECC and its owner, Barry Cadden, have since been the subject of numerous complaints, resulting in a series of investigations by the state and the FDA. These investigations led to the Board of Pharmacy's proposed reprimand and probation in 2004. This proposal was inexplicably weakened in 2006, allowing NECC to continue to operate without disciplinary actions, pending an independent evaluation of its progress under a consent agreement. The Board of Pharmacy's failure to take decisive disciplinary action in 2006 on these complaints has contributed to these tragic events. In April of 2006, the Board of Pharmacy staff learned that the principal of PSI, the evaluator for NECC, had been convicted of federal crimes that resulted in 18 people being blinded. However, the staff did not share this information with board members before they accepted the report from PSI validating NECC's compliance with the consent agreement. These same staff members failed to act on a July 2012 report from the Colorado Board of Pharmacy that NECC had violated both Colorado and Massachusetts pharmacy regulations. These staff have been removed from their jobs. Poor judgment, missed opportunities, and a lack of appropriate action allowed NECC to continue on this troubling path. We acknowledge that these lapses, some of which were preventable, but all are unacceptable. From the early days of this outbreak, our department has acted swiftly and decisively. We secured a surrender of NECC's license, shut down its operations, and forced a total recall of all NECC products. We moved to permanently revoke NECC's license, as well as the licenses of the 3 principal pharmacists who oversaw their operations. We also secured the suspension of operations of Ameridose and Alanis, 2 other drug manufacturers owned by Barry Cadden. which, as you know, have been found to have similar substandard practices. While taking these strong and necessary actions, we have re-examined our own state regulations regarding compounding pharmacies. Although our regulations are comparable to those in most states, they need to be strengthened to address the realities of this evolving industry. On November 1st, Massachusetts enacted a series of emergency regulations to bring greater scrutiny to this industry and require sterile compounding pharmacies to report both volume and distribution information to us. Licensed pharmacies will also have to report when they are the subject of any state or federal investigations. We have also begun unannounced inspections of all sterile compounding pharmacies in Massachusetts. Teams are conducting these inspections even as we speak. To further strengthen our oversight over sterile compounding pharmacies, we must explore changes to the law. We've created a special commission to review best practices in other states and to identify stronger mechanisms for oversight for these pharmacies in Massachusetts. As we work to raise standards in our state, we urge Congress to act to strengthen federal oversight. Congressman Markey's leadership on this issue is laudable and would address some of the regulatory black holes that exist between state and federal oversight. As a pediatrician who's cared for acutely ill children and their families for almost 20 years, I must say that I understand the trust that patients place in our healthcare system. We must use these tragic events as an impetus to work together, public health leaders, public health officials, and legislators, to institute reforms to restore this trust and to ensure that something like this does not ever happen again. We will keep the victims and their families always in our thoughts. They are not numbers, they are not statistics, but real people with real lives. As we work to identify responsibility and to implement policies and practices that can be effective and lasting. Thank you. I appreciate the committee's interest in this matter, and I'm grateful to you for acting so swiftly to have us come here to discuss it.
Thank you, Dr. Smith. Commissioner Hamburg, the title of this hearing is a fungal meningitis outbreak. Could it have been prevented? Now, your testimony is 16 pages long. There is one sentence on FDA oversight on the New England Compounding Center prior to the outbreak. Now, this is an investigative hearing. This was a complete and utter failure on the part of your agency, and Dr. Smith, in her testimony, admitted, and the State Board of Pharmacy. The committee's memorandum that we did, we had 25 pages laying this out. Yet you devoted just one sentence of your 16 pages in your opening statement that even talked about this oversight. Over the years, the FDA repeatedly documented numerous problems at the NECC. Many of these problems are similar, if not identical, to the same problems which caused this outbreak. The agency ultimately issued a warning letter in 2006, 6 years ago, stating that if the company did not alter its practices, FDA would seize its product or issue an injunction and effectively shut down NECC. Now, we heard Dr. Smith. You heard her testimony this morning. She talked about the mistakes they made and what they're going to do to correct it. You're here with your opening statement. You're practicing plausible deniability is what you're practicing. When FDA issued the 2006 warning letter, did FDA have the authority to do what it said, namely seize the drugs and shut down the company? Yes or no?
I think it's important. The fact is,
the question
warning
is,
letter
did you have the
not
authority?
involve sterility failures, and it was not in relation to the kinds of problems that we're addressing now.
So you're saying your letter was an empty threat?
You know, I think one of the great challenges.
Now, the real question is, did you think you had the well, not your letter personally,
I think
but
it is important to understand that I was not.
No, I understand that, and I appreciate that. And I'm just saying that the frustration we have
warning
is
letter and the inspection it was based on had to do with a different set of concerns.
Let me rephrase the
sterility
question. Do you think the FDA had the authority to shut down NECC? Yes or no?
I think that is a very, very complex question, and that the
so you
legal
can't answer that
framework
yes or no?
for FDA activities.
Okay, let me ask another question.
Unclear,
if you're not going to answer the question,
limited.
let me answer it.
May she answer the question
Well, she's not answering the question, Mr. Wax. Well, I've asked her yes or no, and she won't answer the question. This is my questions can be asked. You can ask your question.
You know, I think that the answer to your question is that even on much smaller regulatory actions, the FDA authority to act was contested. Even going into NECC to do that inspection in 2004,
okay,
we did not.
Let me interrupt you.
Access
I'm
to
asking the
records
questions,
that we
and I only have so much time. You issued a letter in 2006. You said you were going to shut it down if they didn't improve on their quality assurance. Was that an empty threat? Did the FDA think they had the jurisdiction, they had the responsibility to shut it down?
The warning letter concerned, first and foremost, an issue that had to do with making copies of a commercially available
We have a different interpretation of my question.
issue.
Let me interrupt you and ask you another question. When the FDA inspected the NECC in 2002, that's 10 years ago, there was evidence that people had been infected by contaminated NECC products. Some of those people were experiencing meningitis-like symptoms. What proof did the company provide then that it had corrected these problems?
Well, as I think you understand from the documents we provided and the information that's been discussed, we went in and we found problems. We worked closely with the Massachusetts Board of Pharmacy to address them, but it was determined that the primary responsibility for overseeing NECC was Massachussets because they were operating.
So you were
as a
deferring
compounding
to
pharmacy.
you were deferring to the state
So
of
we
Massachusetts.
worked with the state. We tried to provide help and assistance.
All right.
But the responsibility for assuring
So it's not your job, it's the state of Massachusetts. Okay.
Was
Let me ask
in
this
fact
last
not
question.
our direct responsibility.
Before the current outbreak, the last time FDA inspected the NECC was in January 2005, which led to the warning letter. The warning letter stated that FDA may conduct follow-up inspections to ensure that the NECC was in compliance. There was not a single follow-up inspection that occurred after 2005. Is that correct? Yes or no? Can we repeat the question? There was not a single follow-up inspection that occurred after 2005.
We did not do.
Okay.
Again, I have to.
Okay,
make
that's
clear
a yes.
That I was not present.
All right, let me
at the
finish.
time,
After
and
noting,
it's my understanding, and I cannot speak to all of the issues that were involved.
You're
there,
taking my time. Let me finish. After noting violations upon violations upon violation in 2002 through 2005, why did the FDA feel confident that the NECC would correct its violation, obey the law? I mean, you had all from 2002 to 2005, all these violations. What made you think that they would correct them?
With respect
and not
to
you
the first
personally, I
set of
understand you weren't there.
violations concerning the sterility issues, those were very serious concerns. We acted aggressively in partnership with the state of Massachusetts. But the day-to-day responsibility for overseeing the practice and remediating the sterility failures were taken on by the state of Massachusetts, who had the primary day-to-day oversight of this compounding pharmacy. A consent decree was reached in 2006, and we had understood, as had the Massachusetts Board of Pharmacy, that they were appropriately addressing those sterility concerns. We had gone in relation to a different complaint from a company about the copying of an FDA drug, and in that instance, we went in relation to the manufacture of a specific product, Trypan Blue. It was not an issue of sterility failure or the conditions in the facility, but it was a practice that we felt they should not be pursuing, and that was what we were trying to address.
My time has expired, and I recognize the ranking member from Colorado, Mr. Gett.
Thank you very much, Mr. Chairman. Dr. Hamburg, I want to try to clarify what's going on here, so I would appreciate short answers also. Now, most of the FDA inspections into this manufacturer, NECC, were about 10 years ago, correct? And that was under the FDA, under the Bush administration, correct?
That is correct.
Okay. Now, in 1997, I was actually here then, the FDA Modernization Act excluded the small, well, it excluded drug compounders for the most part. Is that correct?
That is correct. If a pharmacy was operating in accordance with certain conditions, then they were excluded.
So the FDA didn't have authority over those types of compounders, correct?
That's correct.
So after the 1997 Act was passed, when the FDA received complaints about drug compounding, it had to go over the hurdle of determining whether those conditions had been met or not before the FDA was determined to even have authority. Is that correct?
Correct.
So what happened here is that the FDA was contacted in 2002 about some problems. They went into NECC. They found some problems, and there was a whole series of investigative efforts after that, correct? And one of the issues in this case and in other cases was whether the FDA even had authority to be investigating complaints, whether or not this particular manufacturer fell under the appropriate criteria, right?
With respect to the public health threat that was identified in 2002, we went in and aggressively investigated and worked with the state of Massachusetts to get those contaminated products recalled to prevent ongoing damage to patients. Then, because this was a compounding pharmacy with the primary responsibility for oversight resting with the Massachusetts State Board of Pharmacy, they were responsible for the efforts.
Who is they?
The Massachusetts.
Massachusetts was primarily responsible because it was a compounding pharmacy,
because it was a compounding
right?
pharmacy.
So in other cases, not particularly NECC, but in other cases, when the FDA tried to assert jurisdiction over compounding pharmacies in similar situations, they were actually sued in court. The FDA was sued in court by these companies saying the FDA didn't have jurisdiction over these pharmacies, correct?
That is correct.
And in fact, there's a court case that covers part of the whole country that says the FDA doesn't have jurisdiction. Is that right?
The challenge we have today is that there is a patchwork of legal authorities that really oversee the regulatory actions that we can take. We have a split circuit court decision. There's a map that we have that shows that, you know, unfortunately we have unclear, fragmented legal regulatory frameworks that make it very hard to understand how best to exercise.
Well, and so if you have an emergency like this, sometimes what you're afraid of is you're going to act aggressively, but you're afraid that you're going to be hauled into court, and that's why oftentimes you go to the state regulatory agency. Is that correct?
Well, absolutely. The fact that we have unclear, limited, and contested authorities and ambiguities in the law and a crazy quilt of legal authority has required us to be very reactive, responding to those serious public health threats, and selective. And of course, every effort is resource intensive, as you say, and often will end up in litigation.
So let me ask you this: is if Congress clarified what we meant through in the 1997 Act with these large compounding pharmacies that we, yes, indeed, intend to give the FDA jurisdiction, that will help you be able to protect these patients better by either doing inspections to prevent these problems in the first place or by requiring quick recalls. Is that correct?
Absolutely.
Thank you.
Clearly need additional
I just want to ask
authorities.
a really quick question of Dr. Smith. I really appreciate the efforts that you're making since you took over, but again, most of these things that happened, in fact, all of these things that happened before your tenure, Dr. Smith. And I guess I'd like to know, and in reading all the documents and all of the history of this, it is obvious to me that the ball was dropped in a big way by the Massachusetts regulators. And so my question is, what is Massachusetts doing now to make sure this never happens again?
Well, I agree with you that there were certainly missed opportunities and lapses of judgment that demonstrate significant irresponsibility, and we've taken action with the staff that demonstrated that. In terms of what we're doing now, I think the highlight would be the enactment of the emergency regulations, importantly, which would allow or require sterile compounding pharmacies to produce information regarding volume and distribution. The volume issue being so important because if you're making numerous batches, thousands of vials of material, then effectively you're acting more like a manufacturer than the more traditional compounder. We've also required pharmacies to provide information on any state or federal investigations that concern them. That would allow us to have known that your state Board of Pharmacy had in fact issued a cease and desist to NECC in April of 2011 for the same issue of providing bulk prescriptions that were not patient specific. And lastly, we've done the convening a special commission to really understand what are the best practices in strengthening the oversight of this evolving industry. We clearly are committed to making sure that this doesn't happen again, and we want to do everything in our power to do that.
Thank you. Thank you very much, Mr. Chairman. I appreciate your indulgence.
The chairman of the full committee, Mr. Upton, the gentleman from Michigan.
Thank you, Mr. Chairman. I just want to remind all of us here that this committee has a very long tradition, even before John Dingell, of working with strong members to identify problems in this country, to expose that, and then coming back with legislation to fix it so it doesn't happen again. And one of those is we all review this case and see what was there in the recent inspection, the visible black particulate, the tacky mats, the leaking boiler, the bird in the flying around. I mean, it's just what gives. I mean, what if this was found just recently, and it's our understanding that there are similar types of contamination in earlier years. What is the problem what is the problem by not shutting down something like this until it's corrected? And if you don't have the authority, then we need to make sure that it's there. And it seems pretty reasonable to me that in fact you did have the authority to not only have unannounced inspections, but to come in and correct it so that it didn't get to this stage. Certainly with the deaths of people across the country and the questions that are raised today. And as part of the tradition of this committee, we've got to have the right information to find out if something's off track or whatever. And I guess one of the concerns that I have is in a bipartisan letter that was sent nearly a month ago, we asked the FDA for documents for internal communications to find out what discussions were going on, what was the feedback from the company. And it's my understanding that to date we've got some emails that have come back, but not anywhere close to what we ought to have as we really try to move an investigation forward and try to get to the very bottom of this and make sure that it never can happen again. And I would ask Commissioner Hamburg if we can have a commitment from you as it relates back to the letter that we sent on October 17th, that we get the full cooperation from your staff so that we can come back and ask questions and really try to get to the bottom of this to identify where are the problems, because clearly they were there, right?
We will work very hard with you. We appreciate the work this committee is undertaking. We have tried to get you documents in a timely way. We've, so far been able to get you nearly 2,000 pages of documents, but unfortunately we're also pursuing the active public health investigation response, and many of the same people that are involved, have the right expertise and knowledge of the issues, are working on that at the same time that we're trying to get you that information. And of course, as Congresswoman DeGette pointed out, this concerns activities, some of it going back many years to a different administration and different employees at the FDA, so we are going through trying to get all those documents, and we will be continuing to provide you with the information you've requested.
Well, I just want to say I had a long discussion last month during the break with my colleague from Michigan, Mr. Dingle, very frustrated about what was going on, wanting to get to the bottom of this, wanting to make as we all think about the FDA's proper role, I mean, this would be it. I mean, as we all identify facilities in our own districts, I know that when I go visit, it is clean as a whistle. It really is. The people are proud to have the jobs that they have. It's as sterile as you can imagine. And I can't, for the life of me, as we read about this information from eyewitness accounts and inspections that were there before, and to have it go on and on and on without a follow-up, that is not what anyone is expecting the FDA to do. When you find this stuff, it needs to stop. And as Americans, we demand that for manufacturing here. We also expect it to happen overseas. In your inspections in China and other places, that the products that are being produced are safe not only for Americans but all humans. And when we get terribly frustrated. I know you tried to call me yesterday afternoon. It was my first day back, and we're going to continue to communicate, I can assure you. But we want to get to the bottom of this. We want to find out what really did break down, and where are the questions that have to be answered so that, in fact, you do have the baseball bat to go after these companies that are it's not right. And this is not going to be the last hearing, because we don't have the information that we need to proceed. So I would like to get and I know my time is expiring, but we'd like to get a commitment from you that, in fact, you will be totally responsive to the questions that are asked by Republicans and Democrats, so that we can figure out where this train got off the track, so that we can put it on and we can assure every person in this country that, in fact, the FDA is working as it should, and we shouldn't have to hear the stories that we did earlier this morning with Mrs. Lovelace and our constituents, whatever state that they're in. And I'd like to get that from you and just assure you that this is not a one-time deal.
You have my absolute commitment that we will continue to work with you in all of your requests for additional information. You've also touched on a very important point that I want to underscore, though, which is that we have responsibilities for oversight of manufacturers and drug facilities in this country and around the world, but our authorities to provide oversight of drug manufacturers is very different than our authority to oversee compounding pharmacies, which are, in fact, exempted from important aspects of FDA law. And there's, this disconnect between different legal requirements in different parts of the country as well. We have ambiguous, fragmented, unclear, and contested authorities in this particular realm of pharmacy and drug manufacturing practice, and that is what our opportunity is now, and what our responsibility, I think, is to work together to really create new legislative authority that defines the best approaches, that gives us the broader authorities that we need to address this growing arena of what we call non-traditional compounding that involves larger volume, more complex products, including sterile products, and broader distribution, potentially putting more patients at risk. And there are gaps in the oversight authorities of the states, who have primary responsibility for overseeing compounding pharmacies, and the FDA, and we need to make sure that we have a seamless system that protects patients.
Gentleman from California, Mr. Waxman, recognized.
Thank you, Mr. Chairman. I want to commend Chairman Upton for his statement and his questions, because I think this committee needs to respond on a bipartisan basis, and I think we need to correct the law, and we ought to try to do it before we leave at the end of this year, for this simple reason. When you get into the next year, some of these interest groups are going to gear up to stop legislation. They'll say that we really don't need to have the FDA look at these compounders. FDA regulates the manufacturers, but the compounders are going to be regulated at the state level. Now, you're being criticized, Dr. Hamburg, as the head of the FDA, for the problems that were primarily the responsibility of the state of Massachusetts. And often we hear on this committee, we ought to let the states handle things, not the federal government. In fact, I want to express some sympathy for you at FDA because you're in a no-win situation. When the FDA asks for more data to determine whether a drug is safe and effective or takes enforcement action for violations of good manufacturing practices, the agency is accused of being a job killer, an overregulator. But now, when something terrible happens, we hear that something went wrong, and everybody's quick to jump on you for not doing enough. Now, if we expect you to do more, we better be sure that the statutory law that gives you enough authority to do your job, if we want you to do the job and not the state to do the job. And let me be very critical of the state. The state of Massachusetts dropped the ball. They entered into a consent decree with the company and said, it was a weaker consent decree than they originally started with, and said, oh, you ought to get an independent inspector. So the company hired an independent inspector. And then the independent inspector came back and said everything's fine. And then there was questions about whether this was really an inspector that was independent, which is a good thing to keep in mind when we say let the companies decide who to pick to investigate themselves. So let's look at what we can do now. How many compounding pharmacies are there in the United States?
You know, we don't know the exact number because they are not required to register, and so, you know, we're really uncertain, but there are thousands of pharmacies that do compounding. We think that there are about 7,500 pharmacies that do more so-called advanced compounding and about 3,000 facilities that are doing sterile compounding.
Now, compare that to manufacturers where there's no question you have the jurisdiction to inspect them and to approve their drugs and to recall their drugs. How many manufacturers are there, facilities compared to the compounding facilities?
You know, there are about 5,600 manufacturers that we provide oversight for, including regular inspections, and there is a broader array of facilities that we also oversee in that context.
Well, in 1997, Congress attempted to codify an FDA regulatory system with respect to these compounding pharmacies. But then the Supreme Court later invalidated a part of that law, and raising the question of whether the rest of the law is still in force. Some have argued that FDA still has the ability to cobble together other authorities to act to prevent this tragedy caused by NECC. I don't know if that was a realistic possibility or not. What I do know is that at the very least there's a dangerous lack of clarity in FDA's authority here, and we should fix that. Do you think there's a lack of clarity?
I think there's an enormous lack of clarity, and I think we should seize this opportunity to address it.
What authority and enforcement tools does the FDA need to better enable you at the FDA to take effective action when you discover problems at compounding pharmacies?
Well, we feel that there needs to be a risk-based framework that enables us to play our critical role in overseeing drugs that are going to the American people. Compounding has an important role in addressing medical needs, and traditional compounding is probably best overseen at the level of the state, though it should always be undertaken by a licensed pharmacist or physician, and in accordance with a prescription for a patient for a specific medical need. But there is this area of non-traditional compounding where we think really there needs to be focused attention and new legislation.
Now, all pharmaceuticals that are compounded don't need to be regulated by the FDA, because the traditional way we think of it is a pharmacist putting together a prescription for somebody who has a special need. But now we have an example of a company that's shipping it all over the country. They're making a drug and they're shipping. They're like a manufacturer. of the drug. What we need from you is very specific authorities that you must have to be able to deal with this. And the second thing we need to recognize is your budget. Because if we give you authority, and there are thousands of compounding pharmacies, your agency, I can't imagine, has the resources to regulate every single one of them. And you need to rely on the states to complement the FDA's oversight. Is that a fair statement? Did you
that is
rely on
certainly
the
a fair
states?
statement. And with respect to the authorities, I did outline in the testimony, but we clearly believe that for non-traditional compounders, there should be federal standards that would establish basic safety measures, including sterility controls, could be enforced by the state or by the FDA, but those need to exist. Then we need standards, new authorities around registration, so we know who's out there and what they're making. We need to be able to review records.
You're absolutely right. And I want to say to Chairman Upton, and for the record, all the members of this committee, that we need to get this information. We have to get the right balance. We ought to do it before we leave at the end of the year and make it very clear that we're not just saying, you're at fault, somebody else is at fault. We're going to be held responsible as members of Congress to make sure the law is clear and that the agency has the ability and resources to do the job that everybody expects you should have done. And we want to make sure that you're able to do it. Thank you, Mr.
Gentleman, time expired. The gentleman from Texas is recognized for 5 minutes.
Thank you, Mr. Chairman. I mean, we have a tragedy of significant proportions here. 32 people have died, probably more will. We've got a bipartisan investigation for this subcommittee, and we understand that, you know, business as usual is not acceptable. Having said that, apparently the FDA has decided this is something that they can use to be able to get more authority to regulate or inspect certain transactions that compounding pharmacies do. If there really is a lack of regulatory authority at some level, then that's a legitimate policy recommendation. But if there's not a lack of regulatory authority in existence at state and federal law right now, then it's unnecessary. And my first question is to both Dr. Hamburg and Dr. Smith. Are y'all both stating that under current state and federal law, neither the state nor the FDA had the authority to seize these drugs or to shut this company down?
I think it's important to understand
I don't need a long. I think it's important. Either if the state of Massachusetts doesn't have the authority and the FDA doesn't have the authority, that's one thing. But we have a warning letter, 2006, issued by the FDA. Now, this is before you were the commissioner. It says failure to promptly correct these deviations may result in additional regulatory action without further notice, including seizure or injunction against you and your firm. So in 2006, in the FDA's warning letter, it was the thought at that time that the FDA had sufficient authority, and Dr. Smith, on behalf of the Massachusetts, she's only been on the job 3 weeks, so we can't hold her liable for what happened, 10 years ago, 6 years ago, 7 years ago. But I don't think there's any question that if Massachusetts felt there was a violation, they had the authority to shut it down. So, I think we ought to work on using the authority that we have as opposed to trying to get additional authority at the federal level. The FDA went in and inspected this particular company on at least 2 different occasions. And as far as I can tell, other than issuing one warning letter, didn't do anything at all.
The truth is that in the initial inspections, we worked very closely with the Massachusetts Board of Pharmacy, which has the responsibility for licensure and oversight on a day-to-day basis of compounding pharmacies.
So again, go back and answer my question.
To make sure that the contaminated product was recalled and not continuing to put people at risk. Our first priority.
So you're saying you do,
was,
the FDA did have the authority or did not have the authority?
We worked closely with Massachusetts, who had.
Can you ever give a straight
primary
answer to the
responsibility
question?
for the oversight
Either you
of
do
that
or you
facility.
don't.
I think, you know, what is very clear is that.
What's very clear is that you don't want to answer the question.
No, it's complicated, and that's reflected here. But the responsibilities are different. What FDA has clear and strong responsibility for an oversight
Let me ask
of
Dr. Smith.
is drug manufacturers,
Dr.
which
Smith,
are held to a different
does
standard. Compounding
does your state
pharmacies
agency have the authority to shut this company down if you see a clear violation of the law? Yes or no?
Yes, it does, and
Okay.
in fact, when
Thank you. Now, if you
But the state of
at least you got
Massachusetts has the oversight responsibility for compounding pharmacies on a day-to-day basis. FDA has a different set of authorities, and the challenge is that these authorities, as evidenced by that map, are fragmented, and what enforcement actions we can take have to be seen through different lenses in different parts of the country.
All right.
We don't have clear.
I'm gonna try one more time, Dr. Hamburg. Under current law, does the Food and Drug Administration of the United States of America have authority over adulterated drugs?
We have authority over adulterated drugs, and we can
Thank
take
you.
actions in relation to that.
Okay.
Someone from Texas have one additional minute, and I would ask.
By unanimous
yield
consent,
to me.
so ordered.
I'll be happy to yield to my good friend, the gentleman from Michigan.
Huh?
I thank my friend. Commissioner, two agencies here have dropped the ball. The Massachusetts agencies had to fire its head because it didn't do its job. Your agency, and I don't want you to be defensive, I just want you to recognize a hard fact. Your agency did not use your power to define who is a manufacturer. Here you've got an agency that in just one has sold over 17,000 doses in something like 23 states. Don't you have the authority to define who's a manufacturer and who's a compounder? And if you do, why didn't you do it?
The problem is that the current legal regulatory framework says either you're a compounder or you're a manufacturer, and there in fact
you may define both, may you not? You have that authority, and you did not do it. And I thank the gentleman for yielding.
The concern, though, is that if it's all or nothing that way, then these facilities, if they were defined as manufacturers.
Commissioner, we are trying to solve the problem. This is not an issue where you are here to defend yourself. If you choose to do that, you're going to have a very hard time in this committee.
Well,
we do not tolerate that kind of foolishment, and I would assure you that you are putting your head in the noose. I would urge you to just cooperate with us and with my good friend and give us the answers that we need.
All right, now,
so that you can address your
If
problem.
I can reclaim the time that I no longer
to
have.
recognize where we are, we had unanimous consent to give Mr. Dingell 1 minute, and the time now belongs to Mr. Barton.
I'm just going to.
If you finish up, and
Yeah,
we'll
I am
move
very
on
quickly.
to
I want to be explicitly clear. If there really is a regulatory gap, based on the record that I've reviewed, I don't believe there is. But if there is, I suggest there is a bipartisan coalition on this subcommittee and full committee that will move legislation to correct it. If, however, there is no regulatory gap, I also think there is a bipartisan coalition on this subcommittee and full committee to work to make sure that the state and the federal agencies with jurisdiction work together to solve this problem and to prevent it from happening in the future. And with that, Mr. Chairman, I yield back.
Yield back. And I want to thank the Dean of the House Representative for his taking the initiative to really get the Commissioner to answer the question that most Mr. Barton and myself and others have asked, is whether you have the jurisdiction, and I think the answer is yes. We recognize for 5 minutes Mr. Dingell.
I thank you, Mr. Chairman. Commissioner, I would appreciate yes or no answers here. Do you have sufficient authority to inspect compounding pharmacies? Yes or no?
No.
Will you please submit to us what authorities you need so that we can see to it that it is done? Do you have the authority to access all records when inspecting a compounding pharmacy? Yes or no?
No.
Please submit to us the information and rather on what you need so that we can see to it that that is given you. Do you have authority to require compounding authorities to, compounding pharmacies to register with FDA? Yes or no?
No.
Would you please submit to us the authorities that are needed so that we can address that problem? Do you have the authority to require compounding pharmacies to report adverse events to FDA? Yes or no?
No.
Would you please submit to us what authorities you need in that area? You heard earlier my question about whether or not you have the authority to define who is a compounding pharmacy and who is a manufacturer. Do you have authority to do that or not? Yes or no?
Yes, on a very technical level.
If you need some reform of that authority, please submit that information to us.
We definitely.
Commissioner, do you have the authority to require compounding pharmacies to follow good compounding or something equivalent to good manufacturing practices? Yes?
No, we do not.
Would you please submit to us the authority that you require? Now, this question to both you and to Dr. Smith. Do you have sufficient authority between your agencies, state agencies, and the federal agencies to assure that you are able to coordinate your authorities and to achieve the necessary controls over both manufacturers and compounding pharmacies?
I believe we do not.
You do not. What's your view on that, Dr. Smith? Yes or no?
We don't regulate or oversee manufacturing, so.
Okay, but can you define a compounding pharmacy so that you can define your authority? We have here something where a major problem fell between the cracks. Please submit the answer to us for the purposes of the record. Now, again, to the Commissioner. Do you have authority to require compounding pharmacies to indicate on the label of their product that the product was compounded and not approved by FDA? Yes or no?
We do not.
Would you please submit the authority that you need? Commissioner, it does not sound to me like FDA has authorities to oversee compounding pharmacies. And there's a question of your authority to define who is a compounding pharmacy. Do you have sufficient authority to oversee compounding pharmacies now? Yes or no?
We do not. No.
Okay. Please submit to us your suggestions for that authority to be given. Do you would you submit to the committee any additional authorities that I have not been able to define here this morning that we should address to you? Now, Commissioner Hamburg, your agency is in receipt of 2 letters dated October 9 and 16, 2012 from my office regarding this situation. When will you submit us a response to those letters so that we can have that information available to us as the committee proceeds?
We will get you those responses
as soon as you comfortably can. Mr. Chairman, with thanks, I return to you 24 minutes. One more question, Mr. Chairman. Those 2 letters, I would ask that they be inserted in the record and the response that will be received by the.
We've seen those letters by unanimous consent so ordered.
Thank you.
And I thank the gentleman from Michigan. The gentleman from Nebraska, Mr. Carey, is recognized for 5 minutes.
Thank you, Mr. Chairman. I want to follow through on some of the gentleman from Michigan, Mr. Dingell's questions, because I really do think that's the heart of us trying to figure out where our jurisdiction lies or doesn't lie with the FDA and our role. So I have toured compounding facilities in my districts, which usually are small operations in the part of a current pharmacy. Somebody brings in a prescription that's unique, they compound it, and it's for that patient. That's compounding. And I don't think the FDA would want, and that's a question for a different day, the jurisdiction to go into every pharmacy that has compounding abilities to make something specific for one of their clients. And that's why that's been reserved, I assume, in those discussions, the gentlelady from Colorado, of why it was put in the state's hands that are best able to do that. So now, when we focus on the New England Compounding Center, it may have called itself Compounding Center, but it was a large manufacturing. We know that through its past violations that have come to the attention of both the state pharmacy board and the FDA in the past. We then have a 2011 incident in Denver where pallets of a drug was found. A Colorado Board of Pharmacies issues a cease and desist. So now what we have is mass manufacturing of a specific drug for non-specific people. To me, that's the definition of manufacturing. So, Honorable Hamburg, is the issue then that the definition of manufacturing within that bill isn't clear enough for the FDA? Because it seems pretty clear if you're mass producing, you're sending it into interstate commerce, and it's not for a specific patient, that's not compounding, that's manufacturing.
I think that this has been an evolving industry and that we do have a problem that existing law and authority
what specifically is
it's on or off.
Let me interrupt you since you talk over us. I'm looking for the specifics in the law that say that there is lack of clarity on the definition of manufacturing, because that seems to be the hook that you're putting your hat on. Can you specify in the act that we have to tighten the definitions?
Currently, as we've discussed, there is huge disagreement about the FDA authorities, and the courts have split on the interpretation of our authorities over compounders.
Will you tell me the parts of the statutes that we need to focus on regarding tightening the definition of manufacturing?
The problem is that with this evolving industry, there is a gray area. If we would be to regulate the thousands of compounders,
that's a great speech. Can you refer me to the part of the statute that we need to focus on, yes or no?
I'm sorry, could you repeat?
Refer me to the appropriate part of the statute that lacks the clarity of which you complain.
The FDA has the authority to act against manufacturers.
And this is
clearly
manufacturers.
We have the oversight of drug manufacturers, and with that comes a set of activities that do not apply to compounders, including
so you will not refer me to a specific section of which you feel lacks clarity. All right. One last question for Dr. Smith. This is very frustrating, Madam. Dr. Smith, you're in a really tough place, and you've done a great job. You presented well today. But I am very curious, with all of the knowledge that was brought to the state board, a colossal failure here. You said you're looking into that and putting the pieces together. I'm just curious, is there any evidence of a special relationship between the state board and this manufacturer? Because it seems like somebody's covering for somebody.
Well, we are as concerned about the missed opportunities as you are, and there are numerous episodes of that. We are in the process, as I said, of reviewing just that through interviews and through the exhaustive document reviews that we're doing, and reviewing the documents that we've produced for this committee. It's thousands and thousands of pages. So I don't know the answer to your question, but we are trying to.
Well, I appreciate that you're looking into that. Just last 5 seconds, Madam Honorable Hamburg. Getting your testimony at 1:30 a.m. Most of us are sleeping then, so I guess the whole purpose was to not let us see in advance your testimony. I yield back.
Gentleman yields back. The gentleman from Massachusetts, Mr. Markey, is recognized for 5 minutes.
Thank you, Mr. Chairman. Ms. Hamburg, I have introduced legislation to give the FDA authority to define which compounding pharmacies should be required to register as manufacturers. Would you support that?
We think it's very important that we have additional legislation in this area, and that compounders in fact register, and that it can be defined what they are doing, what they're manufacturing, and what the appropriate regulatory oversight would be.
I have introduced legislation to give the FDA the authority to require compounding pharmacies to compound safe drugs using safe practices. Would you support that?
I do support that.
I've introduced legislation to give FDA the authority to conduct the same inspections and request the same documents as it can from manufacturers. Do you support that?
It's enormously important that we have the authority to go in and be able to do full inspections and review documents, collect samples, et cetera.
I've introduced legislation that requires compounding pharmacies to submit reports of adverse reactions or safety problems to the FDA. Do you support the FDA having that authority?
It's currently a gap that adverse events are not required to be reported from compounding pharmacies.
And I've introduced legislation to require compounded drugs to be labeled. Do you believe that that authority should be given to you?
We do.
And I might say the legislation also allows traditional compounding pharmacies, those which are just doing individual doses to individual patients, continue to stay under state jurisdiction. Do you agree with that?
Traditional compounding, one patient, one prescription, should be overseen by a licensed physician or pharmacist, but it does not require the FDA oversight. It's this non-traditional compounding area where the volume is larger, the distribution is larger, the products are more complex, where we think we lack the authorities that we need, and we appreciate that you are introducing legislation, and will work actively with you.
Thank you.
In order to achieve the important goal.
I think it's critical, given today's hearing, given what we've heard from the witnesses, the pain that it's caused, the regulatory black hole that obviously has to be closed, that we pass legislation that gives you these authorities.
I agree with you.
So that children will have to look to the history books to find that there ever was such a catastrophe as is being suffered by hundreds of families across the country right now. And so I just hope that we can move quickly on legislation to give you that authority, because I think you are the cop on the beat, and we have to make sure that you have the authority which you need in order to enforce the law. And Dr. Smith, I want to commend you and Governor Patrick for the decisive manner in which you have responded to this tragedy. You have undertaken an aggressive investigation and held the companies involved and some members of your staff accountable, and put in place stringent emergency regulations for compounding pharmacies in Massachusetts. We have learned that this tragedy was enabled by a regulatory black hole that allowed a drug manufacturer, NECC, to masquerade as a pharmacy, producing massive amounts, quantities of drugs with little or no federal oversight, and able to sell these vials all across the country to dozens of states without full federal regulation. And there were complaints that had been reported as long as 10 years ago. Starting in 1999 with the first complaint, state regulators repeatedly failed to take strong action, such as withdrawing NECC's license. In 2006, The state even waived the company's proposed probation as long as it got a clean bill of health from an independent evaluator. But when that same independent evaluator was convicted of selling unsafe medical sterilization equipment that blinded 18 patients, Massachusetts did nothing to make sure the clean bill of health that the New England Compounding Center had received was reexamined. Dr. Smith, have you been able to determine why those decisions were made back then through interviews with the staff that were there at that time?
No, we have not. We have done interviews, as you allude to, and we have not been able to really understand why they made those decisions. In retrospect, clearly there were missed opportunities for the Board of Pharmacy, as you point out, in 2006 to take decisive action, and it did not. And we are trying to understand that, but we don't at this point.
Are all of those individuals' emails and other documents from that period available for review?
Yes, we have produced for this committee thousands of pages of emails, and those are all being reviewed.
Is it possible that some of those emails and documents have been destroyed in the period of time from 2006 and prior to today?
Well, I'm not, I wouldn't be sure of that. I can tell you that the numbers of emails from the prior years are far fewer than what we have been able to obtain more recently.
So Massachusetts is in the very near future going to have the strongest compounding pharmacy regulation in the country. But that does not protect us, does it, from other states having weak laws, which could then sell compounded drugs into Massachusetts.
That's correct.
Or the other 49 states. So you just heard the list of powers, which I asked Dr. Hamburg if she would support being given to the FDA. Do you support giving the FDA those same powers so that they can be the national cop on the beat to protect against one state becoming the place where a rogue compounder then terrorizes and harms the rest of the country?
Absolutely.
I thank you. I thank all of you for your service, and I thank you, Mr. Chairman.
Thank the gentleman, and recognize Dr. Burgess for 5 minutes.
I thank the chair for the recognition. Dr. Hamburg, again, thank you for being here today. Let me ask you, you made a statement a minute ago in response to another member's question that you favored a risk-based system. Is that correct?
We do favor.
Well, let me stop you for a second, because I mean, this company was bad news from the day it started back in the 90s. They, as of my understanding from looking at the materials provided to us, they shipped pre-printed prescription forms to various clinics around the country, clear violation of what they should be doing. And then you have the FDA, not you, but the FDA has assembled a 10 or 15-year history of repeated violations and areas where this company has shown itself to be unsafe. So if you want to have a risk-based system, this company's too risky. You can't risk it. Don't do a risk-based system for this company. It is through and in all honesty, it should have been terminated by the FDA multiple branch points along the way, 2002, 2004, 2006, 2008. We see the documents. It should have happened. Now, I guess listening to your testimony today, I must be given to believe that what you've been doing is collecting the data set so that when Congress finally passed a law to allow you to prevent this from happening, you would then prevent it. Is that what I'm understanding? That you lack complete and total authority to do anything at all, even though you saw this stuff happening?
We worked very hard when the first problems at NECC were identified with the state to address them aggressively. But our authorities around compounding pharmacies are unclear, limited.
We've been down this road before, and we're not buying it. We're just not buying it, Dr. Hamburg. In all honesty, you've got an evidence binder in front of you, tab 15. Look at it if you will. It is a letter dated October 31st, 2008. We've heard other people reference a 2006 letter where the FDA, in writing to this compounding pharmacy, say failure to do so may result in an enforcement action, including a seizure of the firm's products and/or an injunction against the firm and its principals. That's pretty strong language. Now, You lacked the authority to do anything, and yet you sent a letter like this? Was this letter sent in error? You really didn't have that authority, and it was an empty threat? Is that what I'm to understand?
As was pointed out, I was not present at the FDA at the time, and I cannot speak to all of the issues, but there was an effort to assert authority around an issue that was very different than the issue about sterile compounds.
Okay, but this letter was issued in error? Is that what I'm to understand? It was an error that the FDA sent this, even though it was a previous administration, a previous commissioner?
There were, in 2004, the FDA was asked to take a look at an issue that involved a specific product, Trypan Blue, and whether or not NECC was making it inappropriately.
Okay, with all due respect here, and our time is limited. I don't mean to be rude, but we really got to pursue this. Did anyone at the FDA, previous commissioner, previous administration, did anyone get a legal memo from your legal department saying, "Hey, you didn't have the authority to do that, so you better back off"? Is there such a memo in existence?
There was a lot of internal discussion. The courts were split on what our authorities
were. So was there a memo delivered to the commissioner?
At that time, there was ongoing litigation.
May we on the committee have access to those internal memos that said you didn't have the authority to write that letter?
That isn't what I said, and I apologize if it came across that way. What I was saying was that an inspection was done in response to a specific complaint, and then with respect to the actions taken, there was ambiguity in the law, ongoing litigation.
There is no ambiguity.
Discussions within FDA, as I understand it, about
let me try it from another perspective, if I could.
Used to take action.
We all saw on television the company being raided, the computers being seized. Did you do that, and you didn't have the authority to do that?
You're asking me about one specific question that had to do with the warning letter, which is a very discrete and different problem than what we're talking about.
But you assert an authority, which you're now telling us you don't have in that letter.
I think you just need to look at the map and see that the authority that is used to oversee compounding pharmacies is very fragmented. We have different court decisions applying different legal regulatory frameworks to different parts of the country. That cannot serve patients well. We need to have a strengthened and clarified legal regulatory authority that gives us some of the additional authorities over
once again, let me just ask you as straightforward and simple as I can. Do you have the authority to regulate the manufacturer, or if a compound is the manufacturer of these compounds, or if the drug is adulterated in some form? Do you have that authority as it exists today?
We have many more authorities over drug manufacturers than compounding pharmacies, and that limits our ability to effectively ensure the safety and quality and efficacy of products.
Again, let me just ask it in the simplest way that I can. How many companies are out there labeled as compounding pharmacies that ship 17,000 doses of sterile, preservative-free steroids every year?
The problem is that compounding pharmacies are not required to register with us. We don't know how many compounding pharmacies are, in fact, engaging in those kinds of practices. What we do know is that the industry, though, has evolved, and that there are an increasing number of non-traditional compounders who are acting, for example, hospitals and clinics.
Look, we've heard testimony from the widow of a victim, and you could tell that there was some bitterness in her voice against the company or the clinic that had provided the steroid injections. How could they buy from someone if they weren't sure? But, you know, I'm a doctor, you're a doctor, Dr. Smith, you're a physician. I mean, you take a vial off the shelf, you make some assumptions as to its potency and its sterility. If we in this country, we stipulate that because you've done your job at the FDA, we don't have to come and ask additional questions before we administer that to a patient. Now, you're telling me that that is not the case, and that the FDA lacks the authority to assert that the safety and effectiveness of those medicines that are coming off the shelf is in fact valid?
We have the authority with drug manufacturers to oversee the safety, efficacy, and manufacturing quality.
Correct. And if you're making 17,000 doses of sterile, preservative-free, injectable steroids every year, you're a manufacturer. There is no other word for it.
Gentleman's time has expired.
Thank the gentleman.
Let the record show, Dr. Hamburg, He asked you a question. You're under oath. You have an obligation to answer yes or no. Just like Dr.
I was attempting to. I'm
Let the
sorry
record
if
show
if
that
I did not.
Dr. Burgess asked you a question time and time again, the same question, and you would not answer yes or no.
We do
Let
not
me
have
recognize
the authority over
that's
compounding
Dr. Hamburg,
facilities
we
that
understand.
we have over drug manufacturers.
The gentlelady from Florida, Ms. Castor, is recognized for 5 minutes. Oh, I'm sorry. Oh, Ms. Schakowsky, yes, welcome.
I'm going to attempt to ask this question. This is of Dr. Smith. In the aftermath of this tragedy, we have learned some troubling facts about the Massachusetts Board of Registration in Pharmacy and how it dealt with NECC in the past. And it raises some questions about whether the board was too close to NECC and whether the board did enough to prevent conflicts of interest from affecting its decisions. So I wanted to ask you, Dr. Smith, about Sophia Pasidas, one of the members of the board. I understand she is gone now. Is that true?
No, we have asked her to resign, but she declined.
So how long has she served on the board?
I don't have that in front of me, but it has been for several years. She was there in the previous administration.
And what is her affiliation with NECC or its sister companies?
She would previously worked for NECC. I'm sorry, so she started in the summer of 2004. She had previously worked for NECC and then subsequently went to Meridos, the company that was also owned by Mr. Cadden.
So I understand that she was actually Vice President of Regulatory Affairs at Compliance at Meridos.
Yes, and she's the pharmacy of record there.
Did Ms. Posidas adequately recuse herself from board actions related to these companies?
In our review of the minutes of the board meetings, it's clear that on several occasions there's a specific indication that she did recuse herself. However, there are some minutes that are silent on the issue, don't say either way. And because of that, the fact that it was unclear if she appropriately recused herself, although when interviewed she declares that she did, because of the lack of clarity, we asked her to resign, which, as I said, she declined.
So I'm glad that you attempted to take action to remove her, but there's still a lot of questions about whether her role on the board during much of the time when Massachusetts was receiving complaints softened the actions of the board that the board was willing to take against NECC. In 2004, after first identifying significant problems at NECC, the board proposed a tough consent agreement with real sanctions, but something happened in the interim, and the consent decree that was actually signed in 2006 was much weaker than in the initial proposal. Do you know how this happened and why the board proposed weaker penalties even after they had received additional reports of problems at NECC?
We don't know how that happened, and as I mentioned, we are very interested and have been attempting to find that out. Our interviews with board members about that precise issue have been has not yielded definitive information. Most simply state that they don't recall.
So one of the problems with the 2006 consent agreement was that it required NECC to be independently audited, but then let NECC to have significant input into who its independent evaluator would be. So Dr. Smith, did NECC participate in the selection of PSI as its independent auditor, evaluator?
Well, we are unsure. We have been reviewing the records to, in fact, try to determine who did make the final decision regarding who that independent evaluator should be, and it's unclear from the documents that we found who did do that.
And is it common for a party to help select its own evaluator?
I can't speak to whether or not it was common. You could certainly imagine that that would be problematic, but we haven't been able to determine who, in fact,
Is it still the practice?
Well, it would be currently. I'm not aware of any current actions that are involving outside evaluator. As we proceed, as I mentioned, we're really looking at both the best practices around other states for the Board of Pharmacy, and so that would be the kind of thing we would include.
Well, let me just say, at the time that PSI was selected to act as an independent evaluator, one of its executives, Ross Caputo, was facing trial for defrauding the FDA and selling unapproved sterilization equipment to hospitals that caused blindness in patients, and he was later convicted. So in 2006, your agency sent a letter to NECC telling them that they had satisfactorily completed, unquote, the conditions of the consent agreement based on NECC's compliance with the follow-up actions identified in PSA's audit report of the company. Is that correct?
That is correct.
So were any of the Massachusetts Board of Registration and Pharmacy staff aware of Mr. Caputo's federal conviction when they found NECC had satisfactorily completed PSI's recommended actions?
As far as we can tell through our interviews with staff and the board members, they were not made aware of the fact that the primary evaluator, Mr. Caputo, had in fact been convicted of those federal crimes. The staff were aware, but as I've mentioned, and shockingly so, they did not share that information with the board.
Well, you know, we've turned up a number of problems, but one, it seems that the NECC was too close to the board and its members, and it seems like the board was more interested maybe in protecting pharmacists than in protecting consumers. We have a lot of work to do, but it seems like that some of the solutions that we've laid out, at least on the federal level for the FDA, are fairly clear, and I'm hoping that at the state level as well, that these problems will be, you get to the root of them.
Gentlelady's time has expired. The gentleman from Pennsylvania, Mr. Murphy, is recognized for 5 minutes.
Thank you. Dr. Smith, in your testimony, you had stated that you've uncovered a number of problems where PSI executives and others did not provide information to people. You said you have found no evidence to indicate the executive directors or staff attorney of the board provided crucial information to the board, and yet the board had to vote on something without that information. Am I correct?
That's right.
And you've given a number of other examples of a breakdown within the structure and have taken action towards people when you found that they were not properly informing or following the rules. Okay. Is there anything also within the laws, as you understand it, that you have authority within Massachusetts or required to pass information up to the FDA on any of these problems that occur?
There's nothing in our practices or our regulations that I'm aware of that require that kind of
Do you do it anyways?
information share. Certainly, since this investigation or this episode has begun, we've worked in partnership with the FDA and, in fact, have done all of the inspections together. That is an area, as I mentioned, when we move forward to determine what sorts of policies we should have about information sharing, whether it should be required as opposed to on a case-by-case basis.
It's helpful internally to identify those breakdowns, too. Ms. Hamburg, is there someone at the FDA who routinely reviews state actions and communicates with them from your level down to the states when there are problems occurring? Is there anybody who reads or reviews anything with the states at all right now?
There is not a system in statute
But is there anybody who does that?
or in practice where there is that kind of back and forth communication on a routine basis. When there is a serious problem, as occurred in this case, you know, we mobilize into action very quickly. We have
Who is it that's mobilized from the FDA to then work with states?
Different components of FDA depending on the nature of the problem.
Is there a particular person?
We have district offices, and they're sort of the first line in terms of identification of a problem.
Well, I'm just trying to get some
responding.
I'm trying to lay out here that Dr. Smith did a thorough internal review and found a number of breakdowns that people weren't communicating with one another. I'm trying to find out within the FDA, regardless of regulations. Obviously, if someone with FDA was talking to the state, someone has authority to talk to the state. And I'm trying to find out if you've identified structural changes needed within the FDA to make sure you're communicating within the FDA that information is coming to your desk for review. Have you made any of those changes or reviews?
I think part of the issue here is that there are not formalized systems. There certainly are opportunities to improve communication, but it also is a broader issue that
Do you need, hold on, I'm trying to help, and you're obfuscating. Dr. Smith, give very cogent leadership, says there's problems, identify the problems, we went after the problems. I'm just trying to find out, do you even have, you don't have to wait for our authority to find out within the FDA who can have the authority to review these things. Do you have it, yes or no?
Well, I'm not sure what authority you mean.
Well, the authority to review if there's problems with the states in manufacturing, et cetera.
We don't always get the reports is the issue. When we do get the reports, then we have our district offices and our Office of Regulatory Affairs.
Have you met with those people since from the district offices to review?
Yes, we've been working very closely with them. And you know, every day there are issues that involve our working with states.
Well, let me ask another area then, too, in terms of identifying people. In terms of dealing with the definition of compounding pharmacy versus manufacturer, who within the FDA is responsible for defining that?
Well, it's not just an FDA; it's Congress.
But who is it that is who is the keeper of the definition that when you have a question?
But our Chief Counsel's office is.
Have you reviewed with Chief Counsel the definition of manufacturing versus compounding?
I think that everyone agrees that at the present time,
I didn't ask you that.
The law is not clear on this.
Please, I want to know, have you reviewed with someone, you said Chief Counsel, the definition of compounding versus manufacturing? Have you reviewed that with someone? When did that take place?
You know, we've had many discussions on
So
that,
has someone reviewed with you a definition of manufacturing versus compounding?
I think that really, you know, unfortunately, there is not a clear...
Yes, there is. Because in your authority, if you're telling us the crux of your testimony today is you don't have authority under manufacturing, you therefore must have met with someone who told you what the definition of manufacturing versus compounding is. I'd like to know who that is. Or is it you?
Well, you know, I really do think this is a broader issue. I know that you're frustrated by my answers, and I'm sorry that I can't just give yes or no, but this is a very complex issue. The courts of our country are split on these
That's
issues.
not complex. Complex is the life for the 32 victims families have now. That's complex. What you have to do is easy, ma'am. Children growing up without parents, people having without a spouse, living that lonely life, that I submit to you is complex. Leadership is easy if you're willing to accept it, and you are not. Dr. Smith took leadership. She went in and cleaned house and identified problems. What you're telling me is all this smoke and mirrors that you don't have authority. Go look in the eyes of the victim and try and comfort them with that. Ma'am, that doesn't work. I'm asking you a simple question, as everybody else is here, and you can't even tell us if you've talked to someone to come up with the definition of manufacturing.
I have told you we have been working very, very hard
to
try to apply the authorities we have to an evolving industry and a set of situations where we do not have the authorities we need. We don't even have registration of the compounding facilities to know who they all are. We cannot review the records. There are no federal standards to which the compounding pharmacies are held, and the courts have not been able to
provide us with
on
that definition.
who has what is the legal regulatory framework for examination of these problems and enforcement actions. I care deeply about the patients and the families. The mission of the FDA is to promote and protect health. We are as frustrated as you are that we don't have the authorities and the resources.
Then just tell us the definition, ma'am. We'll move from there. I yield back. Thank you.
Gentleman's time has expired. Chair now recognizes the gentlelady from Florida. Ms. Castor, 5 minutes for your questions, please.
Thank you very much. And I appreciate all of us coming together to focus on what we can do to prevent tragedies like this from ever happening again. Now, I do think it is clear that there is great ambiguity in the law. FDA, the law with regard to compounding pharmacies was last written in 1997. It is out of date. And for my colleague from Texas, there is ambiguity here, great ambiguity. And it has been made even more convoluted due to these court cases. And I wish we'd bring this map up on the screen as well so folks watching outside the hearing room can see it. See, in 1997, the Congress passed the FDA Modernization Act. That law contained a provision, Section 503A, which dictated the circumstances under which compounded drugs were new drugs and subject to FDA regulation. In that law, Congress explicitly exempted compounders from oversight and regulation as manufacturers. So I know that's what they're struggling with in trying to answer questions here. Then the court stepped in. And this is where I'd like to follow up on Mr. Terry's question of you, Dr. Hamburg, about exactly which section of the Act lacks clarity and his request that you direct him to it. We're talking here about the entirety of Section 503A, aren't we?
Well, 503A applies in some areas of the country and not in other areas of the country, which is a very challenging situation in terms of our ability to be as effective.
Because in 2001, the Ninth Circuit, whose jurisdiction is the western states, those red states, ruled that the advertising component of 503A was unconstitutional. And then they said, and the rest of 503A is void because it's inextricably tied to the advertising component. Then, a few years later, in 2008, the Fifth Circuit Court, the blue states, there to the south, whose jurisdiction includes Texas, Louisiana, and Mississippi, ruled that the unconstitutionality of the advertising restrictions did not affect the rest of 503A. And unfortunately, the United States Supreme Court did not speak to break the tie or provide clarity. So, Commissioner Hamburg, what has been the impact on FDA and its regulation of compounded drugs as a result of these split court decisions?
It has created a very challenging situation where we have, contrasting legal regulatory frameworks for our actions. 503A applies in some places and it does not. The other tool that we have is our compounding guidance that was written in 2002, but that doesn't have the force of law. It just lays out our best thinking about how to implement.
So then the states have primary responsibility over compounding.
It is very clear that states have the day-to-day routine responsibility for overseeing compounding.
And then you have an industry that has evolved, that now some of the compounders, when you think of the pharmacy on the corner, where it's very important that a lot of our neighbors get their customized compounded drugs. But some of them now are very sophisticated enterprises that are shipping all over the place, and they've outgrown the 1997 law. So now we have to decide how are we going to update it to address the sophistication of compounders out there, and then go after these bad actors, because I think the majority of these compounders are on the up and up, living up to high standards. This is a map from the Compounding Industry and Association, and I'm afraid that has led to some of the bad actors being able to take advantage of this situation and the gaps in regulatory authority. Is that a good summary? Is that an accurate?
That is an excellent summary, and I appreciate you're trying to help me explain this, because it is just an extraordinarily complex situation where, the effort.
I don't think that it is overly complex. I think there's a difference in outlook here on whether you have certain authority, and I think it's clear under the 1997 law in these court cases that compounders were exempted and are not manufacturers. So the Congress has a responsibility now to act and clarify it, and there's got to be additional oversight of the states. If the states, if they're going to drop the ball and they're not going to provide proper oversight, then it's time for the feds to step in and give FDA the tools it needs to prevent these tragedies from ever happening again. Thank you. I yield back.
I don't know if I'm allowed to make a comment, but I think that speaking to the complexity of the issue and the changing, evolving industry overlaid on top of a fragmented and ambiguous legal framework, it is important to understand that this notion of sort of black and white compounder or manufacturer, just is trying to fit a square peg into a round hole. And in fact, if the law is examined, it isn't really adequately defined, but there's this area of outsourcing pharmacies that is increasingly important in medical practice. And if we were to define all of those pharmacies that hospitals now use, they used to make, Dr. Burgess, you would appreciate this, you know, it used to be that a hospital would add the potassium chloride to the IV bag in their basement pharmacy or on the floor and give it to the patient. Now, both because of volume and, you know, concerns about making sure it's made under the best possible practices, that's outsourced to a pharmacy. They are making a product in larger volume and often not making it with a patient prescription in hand, yet it is you know, clearly serving an important medical need. And if we were to treat them as drug manufacturers, that would be simply impossible. They'd have to submit an application, a formal application to FDA for review and action. They'd have to pay fees associated with that as well. They would have to be subject to good manufacturing practice. And so I think we want to work together to make sure that we have a law that clearly defines critical issues and authorities, that enables important patient needs to be addressed, but clarifies the different roles and responsibilities and puts in place some critical authorities that are currently missing.
I'm going to interrupt you there in the interest of time. Dr. Gingrey has been waiting patiently, and Dr. Gingrey, you recognize 5 minutes for questions, sir.
Mr. Chairman, thank you very much, and of course, an extremely interesting and important hearing, tragic in so many ways, lives lost and the number of cases of meningitis as a result of this bad actor. Dr. Hamburg, Dr. Smith, pediatricians both, we appreciate you being here, and some of the questioning, the line of questioning from both sides of the dais, both Republicans and Democrats, have been pretty tough, but they have to be, because if we're going to change the law, if we're going to rewrite the Federal Food, Drug, Cosmetic Act, particularly in regard to Section 503A and the vagueness of that section and the conflicting court decisions, then we have to get this right. And I have some great concerns that we might not get it right in regard to overreacting in regulating compounding pharmacies. Every member of the House of Representatives have drugstores, and they're not chain drugstores. A lot of them just corner druggists that do compounding, where a certain product is needed by a patient, but maybe the manufactured product, it's in a base or something that they're allergic to. So therefore, the local pharmacist has to reconstitute that drug, not manufacture a drug. The drug's manufactured, and just put it in a different way of giving it to the patient. It might even be in a pellet form. Think hormone replacement therapy in some cases, or cream, or a vanishing cream, or something that the patient is not allergic to. So if we get to the point in the line of questioning that Dr. Hamburg received from our long-standing member emeritus, Mr. Dingle, about compounding pharmacy, that worries me a little bit, that we might overreact and get to the point that we're not getting at the problem. It seems to me that this particular company, this New England compounding company, was an unusually bad actor, unusually egregious, and I would be very surprised if there are not multiple lawsuits, and in the final analysis, some folks serving some jail time. And it, you know, I can't understand why, Dr. Smith, I'll direct this to you. I realize you've only been in this position for a few months, and by all appearances and from what I read, you're doing a commendable job. But gosh, this company's going back to 1998, and a bright light has been shining on it at least since 2002. And there has to be some connection between members of this Massachusetts Pharmacy Board, I guess appointed by the governor. I don't know for what period of time. And I think we've got some evidence that there was some cross-pollination where maybe even one of these individuals served on the board of the New England Compounding Center, one of these sister companies. And you know, it's just unbelievable. That's the general public is so disgusted with Washington. I mean, we're reading about what's going on now at the highest level of our military, and this situation where in the 21st century we've got a Food and Drug Administration and we've got state pharmacy boards that something like this could happen. It's almost beyond belief. But it makes me think back to what President Reagan said in reference to the Russians and their nuclear stockpile: trust but verify. And that's the responsibility of this committee, this Oversight and Investigation Subcommittee of Energy and Commerce. Trust but verify, and we're not very trusting today, as you can tell from our line of questioning, and we shouldn't be. That judge, his widow, in the previous panel, talked about his contribution to society in the great state of Tennessee, and his life was lost, but he was just one of how many? Well, we're talking about far too many people. So I would just, in my last second, ask you, Dr. Hamburg, and maybe Dr. Smith could comment as well. Do you think that that the FDA needs, because of this, to all of a sudden have us change the law so that you in the FDA, or whoever succeeds you, has this broad authority over these little compounding pharmacists all across the country who are doing the right thing? They're not manufacturing drugs. They're just trying to provide a service, indeed based on a prescription that has to be written. This company was an absolute crooked operation, and they kill people. But I don't think anybody here should get confused between them and the typical compounding pharmacists at our corner drugstores all across our districts.
Yeah. Well, I think we need a tiered approach, and that's what we are proposing in terms of the need for new legislation. I think that clearly the traditional compounder working locally is most appropriately overseen by the state. But this isn't, sadly, an isolated incident. This is the worst and most tragic, and it should be the last wake-up call to us. But over a period now of, almost 2 decades, there have been problems with compounding facilities, compounding pharmacies, and I think it reflects this gap in regulatory oversight and the fact that we really need a strong, clear, and appropriate legislation. We cannot have a crazy quilt where different parts of the country are subject to different legal frameworks for oversight. We need a tiered system that recognizes the role of traditional compounding and the role of the states, non-traditional compounding, which represents higher risks, and there should be federal standards, and we need to look at a set of statutorily based criteria, factors that in some combination would put people into this category: the type of product or activity, whether it's sterile processing, for example, the amount of product being made, whether it's in interstate commerce, whether it's going directly to the end user or through a third party, and the nature of the anticipatory compounding. And then there's some things that just simply shouldn't be compounded, that should be manufactured by drug manufacturers subject to the full force of FDA authorities. And that would include, certain things that you're well familiar with: extended release, transdermal, biologics, and other kinds of products that, because of the nature of the manufacturing, they really should be made in accordance with good manufacturing practice. They should be subject to the FDA pre-approval review for safety, efficacy, and quality manufacturing.
Hamburg, thank you. I've gone way beyond my time, and I really appreciate the chairman's indulgence. So
Sure.
yield back.
The gentleman from Texas, Mr. Green's right.
Thank you, Mr. Chairman. I think the questions in the testimony today showed from all three panels the problem we have. The NECC tragedy laid bare a regulatory gap that we have between the practice of traditional pharmacy compounding and full-scale drug manufacturing. There's no debate that we want the federal government to license individual pharmacists. That's a state responsibility. Nor is there a debate about whether the FDA should oversee large-scale manufacturing of drugs, which is, I think, on a bipartisan basis what we've heard. There have been overwhelming number of signals, though, about NECC, and which is not your average neighborhood pharmacy. Commissioner Smith, how many different states did NECC sell their products to?
I'm not sure about all of their products, but in terms.
But they did sell it into large states. Did they sell it into Massachusetts?
Yes, they did. 23, I believe, was where they.
23 states, but did they sell their products in the Massachusetts market?
Yes.
Okay. How many states did it send the contaminated injections that led to the outbreak?
That was the 23. They may sell into more, but that was the 23.
NECC was not new to this nationwide shipping. Hadn't they been operating throughout the country for about a decade?
That's correct.
The Massachusetts Board of Pharmacy had been getting complaints and troubling signs from states around the country for that whole period of time. The board received complaints from Idaho and New York that NECC was inappropriately soliciting business. The board received a report from South Dakota pharmacists that NECC was sending blank forms for dosage size that you never use on one person. The board received adverse events reports from NECC products from Florida and New York. And the board received complaints from pharmacists in Texas and Iowa on how NECC was soliciting filling prescriptions. The board also received reports of cease and desist order for NECC in Colorado. Dr. Smith, red flags came from across the country, and I can go over that list of states again. Wasn't it obvious that NECC was operating on such a large scale that it presented a nationwide problem of a sort that warranted greater involvement by the federal government?
Yes.
Did the board in Massachusetts request any assistance from the FDA?
I'm not aware of any specific requests. However, there were, certainly during this most recent outbreak, we've worked together.
Okay, but they've been doing this for 10 years, and y'all have records of it. Did you share those records with the FDA, those complaints?
I'm not aware. I do not recall, and I would have to look back to check, but I don't know that we would.
And I think that's our problem. And I've been on the committee since '97. We never included federal regulation of compounding pharmacists because, frankly, that's licensing and that's a state. But when they're in the manufacturing situation, which they are, then that means they should have been covered by federal law. And I know it's complicated and it's hard for a doctor to explain legal. It's hard for a lawyer to explain some of the legal theories that the courts do. But that's the decision I think Congress needs to make, and I think we have a bipartisan agreement. This subcommittee doesn't do legislation, but believe me, the health subcommittee can. And I don't know if we can do it by the end of the term, and I know our chairman's not here and even our ranking member, but I would hope that we could look at a very quick piece of legislation that we could have a hearing on and to correct this problem. Because if you're a compounding manufacturer in Texas and selling in interstate commerce, it ought to be federal law covering it. I don't expect our local pharmacy board in Texas. They go around and inspect my pharmacists, whether they be in the large pharmacies like Walgreens in our case, or CVS, or I know Rite Aid here, or our neighborhood pharmacists. But they don't inspect necessarily the compounding manufacturers, and that's where federal law needs to come. And I'll be glad to yield to my colleague, and I would hope that we would see movement on the bill on a bipartisan basis.
Thank you. Thank you. Let me ask you this, Dr. Hamburg. When you try to inspect compounded drugs, do you get sued by the compounding industry?
We have been sued on numerous occasions, and we have been challenged in terms of our authorities. There
When
have
you try to regulate compounded drugs as new drugs, do you get sued by the compounding
We
industry?
do not. The authority there is very clear. The expectations on drug manufacturers in terms of what they need to do to comply with FDA law.
When you request documents from compounding firms, do they sue to block you from getting?
You know, we often have to go to the courts and get get warrants in order to get the materials that we need. We do not have the full authority that we need to review documents.
When you're asking a drug company, Merck, when you request documents from them, do they go to court?
No, we have much clearer authorities over drug manufacturers.
When you're inspecting Merck, do they question your authority to inspect?
They do not.
And that's why she needs authority. That's why the FDA needs authority.
Mr. Chairman.
Because it's clear that the drug companies accept the law in the FDA's jurisdiction.
As much as I agree with my colleague from Massachusetts, I yield back my time, but I would hope our committee hearing has done what we need to do and can encourage it.
Well, the gentleman, I think his comments were very appropriate and bipartisan, and I appreciate that. Do you think in your heart of hearts that the Energy and Commerce Health Subcommittee should provide more regulation and authority to the FDA before the end of the year?
I think we ought to respond to the tragedy that happened, and I think we owe it to the families, but also to probably thousands of people who may not have been subject to a death in their family, but an illness because of the practices at this particular compounding company that happens to be in Massachusetts, but it could have been in any other state. But Massachusetts did have warning. There were complaints for 10 years about it. And I would hope that we would have better interstate sharing between the states and the federal regulatory agency, even though FDA may not have had the authority, but somehow in 10 years they could have come to us and maybe we could have given it earlier.
I thank the gentleman. The gentleman from Virginia, Mr. Griffith, is recognized for 5 minutes.
Thank you, Mr. Chairman. I appreciate it. And obviously this is very frustrating. You know, I would like to know what kind of due diligence the FDA has the authority to do. Do you send out letters to doctors saying where are you getting your compound medicines from, or where are you getting your supplies from? And the reason I ask that, and the same thing for hospitals or clinics or other medical providers, because this was not what we think of as compounding. This was manufacturing. In my small area, which is, you know, it overlaps the Roanoke Valley, the New River Valleys, we have compiled a list of approximately 1,415 patients who were advised, based on press reports, they were notified they could have been exposed to fungal meningitis through the tainted steroid injections and other products made by the New England Compounding Center. And we have, you know, a hospital that didn't fortunately use it but had it sitting on the shelf. We had that was the Korean Giles Community Hospital. We had the Insight Imaging in Roanoke and the New River Valley. We had other clinics, including Vista Eye Center, Louis Gale Medical Center in Salem, and Korea and Roanoke Memorial, all of which had these products. And when you have that many, look, you know, I don't represent New York City. This is a fairly, compared to other parts of the country, a fairly small area, and we've got 1,415 people who have to worry about whether or not they're going to get the disease. We have more than that who've already contracted it, roughly 50 confirmed cases in the area. 3 of those, so that I'm being fair, were across the line in West Virginia, but not that far from our medical centers. And when you've got that many folks affected, we're not dealing with a compounder, which is why it's been frustrating all day, I think, for members of this committee when you keep going, our jurisdiction is not clear. Your jurisdiction was clear. These folks were manufacturing. Now, what due diligence did you all take to find this out? Because these are all pretty big operations, and if you just sent them a letter saying, hey, who's providing you with various products, you know, I think they would have complied, and you would have had then the you know, you didn't, FDA, not you, but did some work back under the Bush administration, but then it appears that the ball was dropped and that there was no due diligence going on, that you all weren't saying, hey, who's providing you with this stuff? Because you know what? We've got Colorado involved, we've got Tennessee involved, we've got who made complaints in advance, and we've got 1,415 people who either live in my district or Bob Goodlatt's predominantly. You know, somebody wasn't paying attention. These were not our compounding. This was not your small compounding pharmacy. These were, in fact, manufacturers. And I recognize they were violating the laws, but it's very frustrating when you come in here and say our authority wasn't clear. These folks were manufacturing. What were you doing and what are you doing now to find out if there's somebody else out there who's manufacturing under the claim that they're not doing. I mean, you know, if
well, I
lending
think
money,
your question speaks directly to why we do need legislation and new authorities. Compounding pharmacies are not required.
All right, hang on.
To
I'm not worried about
register with the
compounding.
FDA.
I'm telling you that from the evidence I've heard today, it appears these were manufacturers. So what do you all do to find out if somebody's manufacturing illegally? Because that's what I think we have here. And you keep going back to compounding, and that's why everybody's getting frustrated with you. 1,415 cases, you know, a number of states away is not a compounder. That's a manufacturer.
Well, I think we really do need to clarify that in legislation in terms of
I already heard
what
that. Let me go on to another question because I have limited time like everybody else does. There was marketing going on, and I'm going to switch to you, Dr. Smith. There was marketing going on. They apparently were aggressively marketing bulk pricing, discounts to the clinics. You're aware of that at this point?
Well, yes, those were some of the claims or the issues that had come up before.
Okay. And I guess if they're aggressively marketing to multiple states, are there any memos? I know you weren't there, and I appreciate you coming forward and saying, look, mistakes were made. Did anybody think, hey, wait a minute, this is not traditional compounding, this is a manufacturer, we need to turn this over to the FDA and let them deal with them as manufacturers? Because that's what the evidence, notwithstanding the FDA not wanting to accept some responsibility today at all, that appears to be what happened here, is that somebody was violating the law and pulling a fraud and claiming they were compounders when they were in fact manufacturers. Did that ever come up in any of the notes or memos that you've seen thus far?
It hasn't come up, or we haven't found that level of conversation. What has been clear and remains clear is that Massachusetts law requires one prescription per patient. And so the issue that has come up, as you described, is that clearly you can't do that and still do one prescription per patient.
Right.
One of the things we've done since this has all come to light is to remind all pharmacies in Massachusetts of that. Remind hospitals that if you're getting product, that it needs to be one prescription per patient for exactly the reasons that we've been discussing.
Well, I appreciate that. And Mr. Chairman, I know my time is up, and I appreciate this hearing being held. Earlier today you said, or somebody said, there would be more hearings. I certainly hope there are, and I hope that we can get some answers and why and what we need to do, not on the compounding side, but to make sure the FDA has authority, because apparently they don't, to just check and see if we have people out there who are committing fraud on the public by claiming to be a compounder when they're in fact manufacturers.
I thank the gentleman, and I say to all the members, we're going to go for a second round. I think I talked to the ranking member. She's agreed. It's not necessarily going to be the full 5 minutes, but if you, the panel will be patient with us. There's no votes today, so we do have this unique opportunity perhaps to have a second round. I want to continue with a little bit what Mr. Griffith indicated. He sort of indicated going forward today, have you come up with procedures and interpretations so that the manufacturers are out there that are doing the same thing as NECC, that you can stop them? And I you didn't seem to give a clear answer. So what assurance do we have in the public mind and legislators that the FDA is going to prevent this from happening today? Because we might not get legislation. This is a lame duck session, but the Republicans control the House, the Democrats the Senate. I mean, it's going to be very difficult to get legislation through normally, even though this is a very serious problem, and I think we're all bipartisan on this. Sometimes between the cup and the lip, it takes a while. So I think Mr. Griffin was touching on what assurance can you give the public that the other NECCs that are out there, that you're going to stop them?
Well, I do want to underscore that I believe that we need legislation.
So you cannot
to
stop
and clarify
unless you have more legislation.
In the interim, we are working very hard, working with our colleagues at the state. I mentioned, that we are actively engaging with the states in order to both provide our best possible information about best practices.
Do you feel confident you could stop another NECC with the jurisdiction and the understanding you have now? Could you stop another NECC who is manufacturing drugs? Could you stop them today?
NECC was not the first, and it will not be the last until we work together to clarify and strengthen the laws that surround.
Dr. Smith, you indicated in your opening statement that because of what happened, people have been fired and suspended. Is that true?
Correct.
and you've also implemented new regulations and new oversight interpretations so that you can prevent this from happening again. Is that correct?
Yes.
Okay. Dr. Hamburg, have you fired or suspended anybody at the FDA because of this tragedy? Yes or no?
Matt, no.
Okay. Have you gone through introspectively, looked at the agency and said, these are the regulations, these are the things we need to do to prevent another NECC? Have you done that?
We have done that. We have been working very hard to identify what are the authorities that we need to be able to protect the American people and to help to ensure that they get the quality drugs that they deserve.
With the NECC incident, is it your position today that this could have been prevented by the Massachusetts Department of Public Health? Yes or no?
I believe that we need a stronger regulatory
could they
framework,
have,
but
in
I
your
believe
opinion,
that different actions might have been
but
taken with NECC
see,
that
the problem
could
is
have
you're
prevented
saying,
it, and I wish that that were so, but I think we just have to look at the record that there's been.
Did somebody tell you to filibuster us? Is that way you handle the
I
question?
apologize, but you know,
the question
this is
is
an important issue. I care
you're
about
saying
it,
you
and
did
I
not
want
have
to
the
work with you
authority
make a
to
difference.
stop this. Is what you keep saying today. You don't have the authority to do it. Do you think that Dr. Smith, the agency, should have stopped it? Just yes or no. If you don't know, just say you don't know.
Well,
you just.
I think that clearly Massachusetts was working very hard.
So you think they
to
could have
address
stopped it
the
and you
sterility
didn't have to stop it?
concerns. They were unsuccessful, and it's was tragic. We worked hard with them to limit the acute outbreak,
I understand.
and we want to work with you.
I got two more questions
to make
for you,
sure
dear.
that they have.
Is your position today that the NECC was not a manufacturing pharmacy and that you had no jurisdiction over its business activities? Is that your position today? Yes or no?
NECC is registered as a compounding pharmacy.
No, I'm talking about NECC. Did they, in your opinion, this is the crux of the hearing now, in your position today that the NECC was not a manufacturing pharmacy and you had no jurisdiction over its business activities, is that your position today? Yes or no?
No, that is the subject of an ongoing investigation.
No, but you've been telling us all day today that you had no jurisdiction,
I
it's
cannot
murky.
characterize that while there's a criminal investigation that's underway.
Okay, well, let me get a little more pointed. Is your position today that the FDA could not have prevented this tragedy because you did not have jurisdiction? Is that what you're telling me today?
Yes
or no?
I'm sorry, we can speculate.
You're in charge of the FDA. You're the chief honcho. You're the great poobah of the FDA. And I'm asking you, basically, could you have prevented this tragedy? And you're saying you can't because you didn't have jurisdiction.
I think it is very hard to know if any one action that we might have taken could have stopped this terrible tragedy. I wish that I could identify what that would be. What I can tell you is
FDA did nothing wrong in your opinion?
No, I'm
not 2002
saying
when they inspected and found all the problems, and 2006 when they wrote the letter and said we're going to shut you down. I mean, all that is just too murky for you, and you don't think the FDA has any responsibility?
This is not a forum, unfortunately, that enables us to speak to the.
Well, you've been speaking pretty well. We've given you lots of time.
I think that, what we really want to do together is make sure that this kind of event never occurs.
That's axiomatic. We all understand that. But the question is, we're trying to say that we're trying to understand how this could be prevented, and you're saying you don't know how it could have been prevented by the FDA.
I think that
you haven't fired anybody, you haven't suspended anybody. There's not even clear that you've actually initiated anything. So I think we're leaving with the impression is that thank goodness that Dr. Smith stepped up to the plate and did something, and we're just a little unsure what you're going to do. In fact, talking to the staff, we're waiting, as Mr. Dingle said, we're waiting for all this information from your agency, and we didn't even get assurance when you were asked by the chairman and by Dr. Dingle Mr. Dingle, that we're going to get all this information. I'm telling you, there's so much out there that we have asked for that your agency has not given us. And all deference to you, madam. And you've only been there a short time. I appreciate that.
We will
but we need your assurance that you'll provide it.
That you've requested.
Okay, my time has expired. Go ahead.
I'm pulling myself together. I'm going to ask some questions.
Dr. Hamburg, I think you can agree with me that between 2002 and 2006, the FDA made some attempts to investigate this, and they were pretty inconclusive, correct? Yes or no? Yes or no?
I apologize.
Okay, you're not going to answer that. Let's keep going on. Now, in April of 2002, the FDA began an inspection of the New England Compounding Company, correct? Yes or no?
Yes.
And that inspection continued throughout the fall and winter of 2002 and 2003, correct?
Correct.
Now, eventually, you weren't there. This was not your,
No,
it is not your job to defend what they did. But in 2002, the FDA investigators concluded, after a lot of investigation, that there were jurisdictional issues. Is that correct? Yes or no?
That is correct.
They then turned this investigation. There still was some FDA involvement, but for the most part, they turned this investigator over to Massachusetts. Yes or no?
Yes.
And so what happened at that point was then the FDA did have some involvement, but it was primarily Massachusetts. Is that right? Yes or no?
That's correct.
Now, in the meantime, you know, I will say we are just trying to get answers here because we do need to figure out how to prevent this. And if we can't prevent this kind of a thing, then shame on us, because this is a company that had black specks floating in the vials. It had cleanliness that wouldn't even be accepted anywhere in the world, and we're all sitting here wringing our hands. So we have to figure out how to give you the jurisdiction to do what you need to do, and we have to figure out how to give Dr. Smith and all of the other state regulators like Colorado the ability to work with you to do that. Okay?
Agreed.
And these inconclusive answers are not helping us. Now, the Act, Section 503 of the Act, has all of these requirements regarding the compounders, correct?
Correct.
And what it says is a compounded drug is exempt from a variety of requirements of the Federal Food, Drug, and Cosmetic Act relating to drugs to get FDA pre-approval if the drug is compounded for an individual patient based on the unsolicited receipt of a valid prescription, correct?
Correct.
And it says the drug is compounded by a licensed compounding pharmacy, correct?
Correct.
So what has happened over all these years is these drug compounders have started these great big manufacturing facilities, and then they have the illusion that they're keeping these scripts for the individual patients, but they're really not doing that. Is that correct?
That's correct.
And that's part of the problem, right?
That is.
Okay, now, just hold off. So the other thing that has happened, then, Section 503A says, and this goes to what Mr. Griffith was saying, is Section 503A says that the FDA can take jurisdiction if these compounding pharmacies are exporting more than 5% of their drugs to other states, correct? It says that, right?
503A, yes.
Yeah. So what Mr. Griffith is saying then is, well, why doesn't the FDA just enforce that? But here's the problem, Mr. Griffith, and this is what Commissioner Hamburg's trying to say, is the Ninth Circuit has thrown out all of Section 503, and it says it doesn't even apply. And the Fifth Circuit has said Section 503A only applies to advertising, and that's what that map is about. And so what Dr. Hamburg is trying to say is, you know, we can point fingers and we can be upset and everything, and we should be, about what happened 10 years ago and why this operation wasn't shut down. But what we really need to think about is what are we going to do going forward to make sure that that the jurisdiction is clarified. And I would bet you if we could all sit down and talk about it, we could agree on the same principles. We don't want the FDA having jurisdiction over the doctor in the little mom and pop pharmacy who's trying to make the ointment for the kid. But if it really is a big manufacturing operation, even though it's a compounding pharmacy, we need, if the law isn't clarified now, if there's litigation, if there's a separation of court decisions in the cases, We need to fix that, and that's our job as Congress. So I guess I would say, Dr. Hamburg, you know, I understand what you're saying, but within the purview of the law as it's written now, the FDA needs to do everything it can to make sure it prevents this kind of activity. And furthermore, we have a job. We have a job to all of these victims as Congress to not try to move the lounge chairs around on the Titanic. We have a job to clarify the law if there's not clarity in the law, and we can easily do it. So thank you, Mr. Chairman, and I yield back.
I think we have a little time here. You and I can have a colloquy here because, and Ms. Griffin, you can participate in this colloquy. You're an attorney, Mr. Gett, and I appreciate what you're saying, but I think the interpretation of what you did on the Supreme Court is not wholly explained, as you said. I'm asking staff, did the Supreme Court throw out the entire, what was it, 50?
3A.
Yeah, I don't think they threw it out. They threw out only that portion that dealt with marketing. Right. And so for you to say they threw out the whole thing so that the commissioner and the FDA had no interpretation of
that's
what
not what I said, Mr.
Well, that's
Chairman.
what you sort of implied.
No, what I said,
and the
Mr.
legal
Chairman.
problem is that the Supreme Court only did a very small portion of that and left intact the idea that the company that's manufacturing still can be determined if they are a small pharmaceutical or they're a manufacturer. So I would submit.
Mr. Chairman, if you'd like to have a colloquy, I'll tell you what
well,
I said. What I said was.
I think you'll appreciate what I said.
The Fifth Circuit threw out the 503A provision only on advertising and left the rest of it intact.
Right.
The Ninth Circuit threw out all of 503, and then the Supreme Court took cert on the Fifth Circuit case and on the Ninth Circuit case, but they only talked about the advertising. So now it's really a big mess.
And I agree, because of the Fifth and Ninth Circuit and the Supreme Court. But I don't think, and this is what you're implying, that it creates such a position that the FDA had their hands tied and they couldn't determine what is a manufacturing and what is a small pharmaceutical. I think the
Again,
FDA
Mr.
still
Chairman,
had the
you're misinterpreting what I said.
Okay.
What I said is that there's a lack of clarity in the law, and what that means is that evildoers like this compounding pharmacy don't feel like they have to listen to the FDA. They don't feel like they have to produce the documents when they're requested, and they sue whenever there's anything that happens. And that's the problem, is it ties the FDA's hands when they're trying to take enforcement actions against these folks, even if they want to.
Okay. You're welcome to step in here, but I think I would leave.
Order, Mr. Chairman.
Whose
time is it now?
It's right now. It's hers. I gave her the time, and she yielded back, and I asked her that if I could have a colloquy with her, which she agreed to, and you're welcome to join in. I think this is a legal interpretation, which I think you're welcome to join in.
Mr. Chairman, I wouldn't want you to interrupt your discussion, but we do have members on both sides of the aisle waiting for their opportunity.
Oh, sure.
Second round of questions.
Well, you weren't here at the time, and I'm glad to recognize you. And give me 15 seconds.
No, but it goes to your side next.
Oh, that's right. You're right.
And I want to be
I'm going to take 15 seconds and just say, as a purview of the chairman, is I think what Mr. Gett's talking about between the Fifth and Ninth Circuit Court and the Supreme Court. I know, but I'm the chairman, and what I think is that there was still left the integrity of the law so that the FDA could determine who is manufacturing and who they have jurisdiction over.
Regular order, Mr. Chairman.
With that, I'll recognize the gentlelady from Tennessee.
Thank you, Mr. Chairman, and I have just a couple of questions. You all have stayed with us, and we do appreciate this. A point of clarification, Dr. Hamburg, you mentioned earlier there are 7,500 advanced compounding pharmacists and 3,000 sterile.
That's information that was given to us by the International Association of Compounding Pharmacists.
Okay, well, that's what I wanted to know, if that was
we don't know the numbers
the
because they're not required to actually report to us, so we don't know numbers from our own assessments.
Okay, but you can source that for us. Would you provide that sourcing so that we have that?
Okay, certainly.
Okay, thank you. I appreciate that. I want to go back to this issue that you all had, because you had the Colorado complaint against NECC in May of 2011. Is that correct?
That is correct.
Okay. And that complaint came into you well in advance of any of these contaminated lots being shipped. Is that also correct?
Well, as I understand it, it was a request for information from us about whether they were registered as a manufacturer, a drug manufacturer, and NECC is listed as a compounder.
Well, I think Colorado notified the same FDA compliance officers who had inspected NECC in the past. Is that correct? And
I believe
these inspectors were aware of NECC's past violations. Isn't that correct?
I believe that the email from Colorado was shared within the FDA because of the history with NECC and the
Okay, and then in that email, did they not say that NECC was again shipping volumes of drugs without a prescription?
What they indicated to us was that they were concerned that NECC was operating in violation of Colorado State Board of Pharmacy licensure and registration laws.
But that was,
and they included attachments about the volume of product that was being shipped.
But it was clear that it was a repeat violation. Isn't that correct?
What was clear was there were not specific safety and quality concerns, but they were noting that there were not valid prescriptions for the
Okay, then let me
materials that
ask
were
you
being sent
this.
to Colorado.
Did FDA do anything at all with that complaint?
Well, we suggested that they follow up with the Massachusetts Board of Pharmacy because
You suggested.
it was.
You suggested. You didn't require. Did you even pick up the telephone and call the Massachusetts Board of Pharmacy and say, we think we have a repeat offender?
I understand, what you're getting at there, but it gets
Yes
us
or no?
back
Did
into
you pick up the phone and call? Did anybody pick up the phone and
there
call
was
Massachusetts?
email was being used, but it was
Would you like to
communicated through the Colorado
supply
Board of
all of those
Pharmacy.
emails to us for the record?
I believe you have them.
Okay, we've got all of those in total. When did you personally become aware of the situation? I mean, at what point in the process did you individually, not your staff, but you, become
When
aware of
the
this?
first cluster of meningitis cases and the possible link to NECC was identified, it was
okay, Dr. Smith,
late
let me come
September.
to you with my last minute. Did the FDA ever contact you?
Are you, just so I can understand, do you mean in the past or around this current outbreak?
No, let's go back to the Colorado complaint. Did they ever contact you? Did you ever get a phone call or an email from anybody that said, we think we have a repeat offender out here?
Well, I can't speak to the phone calls, but our review of the emails does not suggest that we got any information then.
So
Not
they
until
knew
July of this
they
year.
had a repeat offender, but they did not call you. With the boards of pharmacy, like with Colorado, back to you, is there any direct contact there? You know, so many of our state boards who do a great job of regulating areas contact and work with other state boards who have like supervision in their states.
Well, we did receive information from Colorado about the action, but it wasn't until July of 2012, and we weren't, or I wasn't aware of that until we discovered that in the process of producing the documents for this committee.
Okay, and let me ask you this. Personnel actions in response to this, the NECC, have you taken any actions there?
Yes, the executive director at the time has been let go from the department, and the board counsel has been put on administrative leave, as was the division director for that area.
And are you reviewing your processes and best practices?
Regarding personnel actions?
Yes.
Yes, as we reviewed the information again that we've presented for this committee, we have identified lapses in judgment which have resulted in these personnel actions.
Thank you. Yield back.
The gentleman from California, Mr. Waxman, is recognized for 5 minutes.
Thank you, Mr. Chairman. I find this hearing amazing.
Amazing.
Because what we need to do is to work together to solve a problem and make sure it'll never happen again. Instead, what I hear from my Republican colleagues is they want to prosecute the director of the Food and Drug Administration. Did she know this? When action did she take? Sounds like Massachusetts has a lot to be apologetic about. Isn't that a fair statement, Dr. Smith?
Yes, you're right.
And the question is, did FDA fail to do things they should have done? Well, sounds like you could have done more. The FDA as an institution could have done more. The first time they wrote a letter was in 2006 saying that this company seemed to be out of control. And then they didn't do anything after that. Now, I have a feeling, Dr. Hamburg, you're being picked on because you're part of the Obama administration. And the Republicans have been picking on Obama for 4 years. And usually their mantra goes, job destroying regulation, let industry police itself, we don't want government involvement. Now they're saying we want more government involvement. And I think they're right. We want appropriate government involvement to stop these things from happening. So you would think that our obligation would be to figure out, do you have the authority? I respect the chairman greatly, but I've never understood him to be a great legal scholar. Seems to be there's some ambiguity. If there's an ambiguity, it's our job to clear it up. You think there's an ambiguity because the law that we drafted in 1997 said one thing, then the court came in, said something else. You don't know whether you can act, whether you can't act. If we want to make sure you act in the future, other than just beat you up for not acting, we ought to make sure that you have all the authority appropriate to act. Courts have thrown out part of that 1997 law. The courts are themselves divided on whether Section 503A continues to have any legal force. In the western states, 503A is not effective. Well, in Texas, Louisiana, and Mississippi it is. And as the map put together by the compounding industry itself shows, there's a very large gray area in between. So why are we looking for anybody to blame other than the company and making sure that the regulators have all the power that they need? That involves, my colleagues, regulatory power to act. It also involves, I tell you, regulators, to do your action, to take action, to stop these bad actors from doing what they want. And I wasn't in the room, but I understand the chairman of the Oversight Committee said, we're not going to do any legislation. Well, I'd rather we do it now before he leaves, because he's so involved and steeped in this whole question. He should want to work with us to solve this problem. It doesn't sound like that difficult a problem. We need to say the FDA has the authority to do this, to do this, to do that. Commissioner Hamburg, can I ask you for a commitment to make your staff available to us this week if we started a process to correct the law?
Tomorrow. We are so eager to work with you because we feel there are significant gaps in our authorities that limit and undermine our ability to do all that we want to do to protect the health and safety of the American people. You know, I think that the fact that we have a situation like that map reveals suggests that we don't have a comprehensive, integrated legal framework for action, and we think that we can work with you to identify critical areas from registration so we know who's out there and what they're doing, to developing federal standards that should be adhered to ensure safe and high-quality products, to the ability to do full inspections.
I don't want to get you off the hook completely. I think you need the law to be clarified. But if I were sitting in your shoes, that's a Bix metaphor. If I were sitting in your seat and I was the head of the FDA and I heard that Colorado was concerned about this situation and you heard other reports, I would have assumed I had jurisdiction. I would have assumed the jurisdiction. I would have acted on it.
Well,
and I have to say to the state, you know, people want to make partisan comments, and I think some of what's going on is a little partisan. When FDA first sent a letter, the chairman said, when you sent a letter, it was FDA, it was the FDA under the Bush administration. When the state of Massachusetts had a weak consent agreement, it was under Governor Romney's administration. You're now here under Governor Deval Patrick and here under President Obama. Let's put partisanship aside. Let's make sure that you have the authority and the resources to do the job. We want you to do the job because we ought to be mindful of the comments that Mrs. Lovelace made and all the other people who are waiting to see if they're going to die from this contaminated drug. We don't want excuses, but we don't want to leave this law ambiguous because you're always sued if you act. And if you act assuming you had authority when you don't, you're usually called before committees to say, how could you act as if you had authority when Congress didn't give it to you? I think we ought to put our partisanship aside, the election's over, figure out a clear law for the federal government to be able to act because, with all due respect, this is not a state issue if a drug's being shipped around the country. It's an interstate issue. Thank you, Mr. Chairman.
Sure, and I'll be the first to to recommend you as chairman of the FDA.
Can we finish this hearing, Claire?
You might not want that job.
All right, Dr. Burgess, recognized.
Thank you, Mr. Chairman. And that's something that was very important. I don't want it to get lost in the translation. Representative Blackburn asked about emails between the FDA regional office and the Massachusetts Board of Pharmacy. And Mr. Chairman, may I suggest that those emails are a critical part of our investigation and that we must receive those, even if it's necessary to exercise subpoena authority. We need access to that because that's a critical part of it.
The gentleman will yield for 1 second.
Yes.
We have tried. We have got no emails from the FDA. You know, the crux of this hearing is to get to the bottom of what happened. We can't get to the bottom if we don't have the information. So you're exactly right. The FDA's got to cooperate and give us emails because we've gotten zero.
Well, and of course, the FDA has a lot of material, and the access to the opinion of your experts would be important to us in this investigation. So the intransigence that Chairman Upton referenced in his opening statement is something that really must be overcome. Now, I'm of the opinion that you had all of the authority that you needed. And yes, it was a previous commissioner and it was a previous administration. So once again, I would also ask that if there is a memo from a general counsel at FDA to the then commissioner about you don't have the authority to do what you said you were going to do in this enforcement letter, I think the committee really should see that as well. And again, I think we should exercise every power that we have in order to get that. And the reason it's important is if new legislation is indeed passed and passed hurriedly as has been recommended before the end of the year, and yet you're not going to act on that authority, then we're going to be right back here in the same soup with the same problem some point in the future. And it may be a different commissioner from the FDA, and they'll say, well, there was ambiguity. Look, there's no ambiguity. You got a criminal investigation going on against NECC. Is that not correct?
There is a criminal investigation, yes.
So where's the ambiguity? If you've got a criminal investigation, if you had all the guys at FDA jackets seizing computers out of the compounder, where's the ambiguity?
First, let me say we are working to get you the emails that you want. We've been trying to develop documents and get them to you as swiftly as we can in light of everything that's going on. You know, I know it's not the answer that you want to hear, but I do think that there is clearly ambiguity and a lack of...
A criminal investigation. Guys in FDA jackets seized the computers, did it on TV so everybody can see.
No, but
that doesn't look ambiguous.
More broadly about the need for legislation. You know, I want to do everything to work with you and get you the information that you need, but I think we also do need to look forward and look at where are the gaps in authorities. I cannot speak to what was going on in the FDA during that period because, as been noted, I wasn't there. As I understand it, there were very intense discussions and conflicts about what were our authorities, there was ongoing litigation, what basis would we use for different regulatory actions that might be taken?
So help us here. If we are going to craft legislation rapidly before the end of the year, as has been suggested several times on the other side of the dais, how do we keep from making the same mistake again? Look, do you have the authority to conduct an investigation as to whether or not you have jurisdiction to conduct an investigation? Because that's what I've been hearing all day.
We have authorities that have been consistently contested, have resulted in split court decisions and a patchwork of regulatory legal oversight. And, you know, that is part of what I think we can and should address together.
Yeah, look, people are dead. Doctors have administered medication that they thought was safe, and their patients have suffered. They've got to live with those consequences. The case we heard about today where the doctors in the intensive care unit at Vanderbilt Hospital didn't have a clue as to what was really the culprit in that gentleman's illness. There's a lot of stuff here that if there's a problem with the existing statute it needs to be corrected, then you owe us the ability to look at those internal documents and see what the discussion. Well, it's been said time and again, we got to do this before the end of the year. Give us the stuff. Or, Mr. Chairman, I am going to ask that we subpoena the stuff that we need and do that forthwith. I mean, yes, I know it's holiday season and nobody wants to be working on this stuff, but we've got to do it. And if we rapidly produce legislation so that we can just say we've done something before the end of the year, so we can all feel good about ourselves, again, we're going to be back here in this same mess. 2 years, 3 years, 4 years, fill in the blank. If all you need for the cloak of invisibility is to say I'm a compounding pharmacist, I mean, what's to stop Pfizer tomorrow from saying, oh, I'm a compounding pharmacist? All this stuff goes out the door, and you can't stop me. You can't touch me because the Fifth Circuit or the Ninth Circuit or someone said that you can't touch me. That's nonsense. No one believes that that's the way it should be. And surely you don't either.
I do not, and that's why I really do feel this is an extraordinary opportunity for us to fix some of these problems that have really been present for now at least 15 years and have tragically resulted in incidents involving deaths, loss of vision, other injuries and harm from drugs that the patients thought would help them, not harm them.
Look,
and so I think we can strengthen.
You owe us the information. You have
and we will get
emails,
that to
you have experts under your control. If this is something that's been discussed internally and there's been a conflict internally, let us be privy to that information so that when we try to craft the legislative fix, it's not an imperfect product. I submit you've got all the authority you need today to have shut this place down, locked them up, sent them away for however long that anyone would care to think. For whatever reason, it didn't happen in 2002, 2004,
Gentleman's
2006,
time has
2008.
expired.
I yield back.
Mr. Dingle, before I recognize Ms. Dingle, Dr. Hamburg, we've gotten thousands and thousands of email from Dr. Smith's agency. So the fact that you've got none, she has less resources than you do, yet they've complied and given us all the information. So I just really urge you and your staff to comply.
We will get.
All right. Mr. Dingle was recognized for 5.
Thank you. Dr. Smith and Commissioner, it is possible for the two of you to execute memorandums of understanding defining your respective jurisdiction, is it not?
Yes.
Is there any reason why you could not or would not begin to devote your attention to achieving such a memorandum of understanding so that you could define where the authorities of Food and Drug lie and the authorities of the agency in the state of Massachusetts lie? Are you willing to undertake that, ladies?
Well, I certainly think that there are multiple opportunities for us to do better in terms of the communications and that sort of thing at the very beginning.
We are going to try, I think you can sense from the committee and its questions, to proceed towards a legislative solution. It may very well be that we have to do so, and I think we're determined to do so. What I'm hoping is that while we are doing that, that you will commence doing what you have the capacity to do, i.e. a memorandum of understanding where the two of you define your respective responsibilities so that we can get ahead of this curve, and if we cannot complete our business by year end because of the Senate or other things, that we are able, therefore, because of your labors, to commence the process of moving along on a parallel track. Are you willing to do that?
We are certainly willing to do that, and we are pulling together all of the 50 states in order to really begin
Beloved friend,
to clarify
I don't
what
want
are
to sort
the roles
out
and
the
responsibilities
difficulties
and the
but
activities.
I want to look at how we resolve the problem.
But I would just have to underscore
right.
that it still won't address the split in the courts
The clock
and the different
runs.
regulatory
It is
requirements.
most uncharitable. I will look to hear you give me an answer on what you can do to get a memorandum of understanding done between your two agencies and or other agencies. Now, it is possible to define a compounder as a person who makes certain amounts, and to define a manufacturer as a person who makes certain amounts of pharmaceuticals, is it not? Yes or no?
You could decide to put that in legislation. Currently, that does not exist in the legislation.
So you're telling me you don't have the authority to do that? You do, or you don't have authority?
In and of itself is not dispositive. It could be put into legislation as a statutory based factor in our
New England
determination.
Compounding Center and other like-hearted rascals have engaged in the practice of figuring themselves a fine loophole in which, through lobbying and other efforts, they have been able to assure that they're able to engage in practices that impose substantial dangers on the American people. Now, having said that, I'd like to have you tell me one more thing here, if you please, Doctor. You have one of the required treatments for this particular fungicidal meningitis that takes place is to have availability of a substance called oral voriconazole, which is a therapy used in treating spinal meningitis. There is a great concern on the part of a hospital in my district, St. Joseph Mercy at Ann Arbor, and they are troubled that there's going to be a shortage of this particular pharmaceutical available to them to provide the necessary treatments for their patients who have been hurt by this particular the particular injectable that we're talking about today. What is there that we can do to assure that there is an adequate, current, and future supply chain for oral voriconazole?
Well, voriconazole has been used in the treatment intravenously, and it is, from the very beginning, we've been looking at the possibility of shortages. When last I discussed that with our drug shortage team, they did not feel it was in shortage. I have not heard anything further. I will get back to you if there are concerns, but I do not believe that it is at risk for shortage at the present time.
This is a matter of urgent concern, and I would suspect if my people at St. Joe's are concerned that you will have hospitals and practitioners elsewhere in the country who will have the same concern. So I would appreciate it if you would please
we have
get
been
back to
examining
us.
that.
Mr. Chairman, I thank you for your courtesy.
Gentleman from Virginia is recognized for 5 minutes. Mr. Griffin.
Mr. Chairman, this is probably a first for me in the time that I've served on this committee, but I agree with Mr. Waxman when he said that he would have made the assumption, particularly in those areas that are gray, that you had the authority. And so I just point that out to you. Now, maybe it's because I was a criminal defense attorney in my prior life that, you know, the threats that somebody might sue me just aren't something that would stop me from trying to do my job. And if I thought I was right, I would have gone forward. And that's why we want to see the emails. We want to see the memorandums. You've heard all of these questions. And I thought Ms. DeGette did a nice summation, and I wish you had been as clear in your answers as she was in trying to interpret your position. But having been a criminal defense attorney and having heard you all day say that, you know, you didn't have authority or your authority was vague or that you need a clarification of authority, I have to ask the question, what is your legal basis for the FDA going in and doing a criminal investigation in this case.
Well, of course, that is being done with the Department of Justice, but the Food, Drug, and Cosmetic Act obviously is the basis for so much of our regulatory actions. But the problem here is that a component of 503A has been questioned in the courts, and it applies in some areas and it doesn't apply in other areas. And we have, around compounding pharmacies, we have guidance that we've put out that would be applying in some areas, but that doesn't have the force of law. So, you know, it is a challenging arena for
well, and here's the problem. And I fear that in your comments today, you may have made the argument for the defense that they're going to escape criminal sanctions because you have said the law is ambiguous and that you don't have the authority to go forward. And I think that's a mistake because, look, you know, I think they're, as I said before, a manufacturer, particularly when we have 1,415 patients in my area alone. I think they're a manufacturer. And just because they call themselves a compounder doesn't make it so. I could call myself the Duke of Earl and claim diplomatic immunity. That does not make it so. And a trier of fact, if you all had been aggressive on this, I believe a trier of fact would have found they weren't a compounder a long time ago, which is why, as you move forward, you didn't answer the question earlier, so I'm assuming that you don't routinely contact medical professionals and ask them where they're getting their drugs from so that you couldn't identify. I think that's what you should have been doing, but hindsight is 20/20, as we all know. But I think you ought to be looking at doing something like that in the future so that you can protect the American public. I think, like Mr. Waxman said, you should have assumed you had the authority when you had a bad actor. And I think as you go forward, you have to look at that. And Dr. Smith, I would hope that you all would look. I believe they may have undermined their criminal case today. So since they've said it was the state's responsibility, perhaps there's a state law that you could look into and ask your attorney generals to look and see if there's any criminal prosecution that could be brought under state law. Because if the FDA doesn't have the authority to deal with them from a regulatory standpoint, I'm not sure they have the authority to go in and seize the computers and do what they're doing. That being said, I would now yield my time to the gentlewoman, Congresswoman Blackburn.
Thank you. I appreciate that. And Dr. Hamburg, I want to go back to this issue with the emails that pertain to NECC. The first violation came up in '02. And please understand that it was unclear in your answer to me about the emails. You seemed to indicate you thought we had your emails. We do not. So let me be very clear. We want to see this entire file going back to '02. We want all of those emails, and we want the conversation that took place via email with the Massachusetts Board of Pharmacy. I have 81 Tennesseans and 13 deaths. We are very concerned about this. We're concerned about everyone that has been adversely impacted. Our sympathies and thoughts are with them, and we are incredibly concerned about the ineffectiveness of the bureaucracy, and it doesn't matter which administration. It is the lack of attention by this agency to a situation that has gotten out of hand. So just to be certain that you understand what we're asking, all of the emails, we are not in possession of this, and we have asked for this. So we do ask that you comply quickly so that we can see the full extent to your participation and the manner in which you all communicated with, responded both on an intra-agency and then also with the Massachusetts Board of Pharmacy. And with that, I will yield back the balance of the time.
Gentlelady's time gives up time, and the gentleman from Massachusetts recognized for 5 minutes.
Thank you, Mr. Chairman, very much. Dr. Hamburg, isn't it true that the legal definition of drug manufacturer in Section 510 of the Food, Drug, and Cosmetics Act exempts pharmacies?
You know, I am not a lawyer, but my understanding is yes.
Yeah. So that
Under
creates
certain
problems right up,
circumstances.
that creates a problem right up front from a legal perspective.
Yeah.
That clear statement that exempts pharmacies from FDA jurisdiction, when it comes to drug manufacturers, that in the actual definition itself, it kind of talks about what would be equivalent of Merck, or Bayer, or Pfizer as a drug manufacturer, and then it explicitly says pharmacies are not covered, in that definition. So that's just loaded with potential for lawsuits, for questions that can be raised about your authority, and you need that clarified so that you absolutely have the ability to regulate compounding pharmacies in a way that protects the public health and safety.
I think that 510 exempts from registration, not any kind of jurisdiction. But I think the problem is that I'm not saying we have no authority. I'm saying that our authority over drug manufacturers is very different, and it requires a set of clear actions on the part of the manufacturers and the part of FDA. In this area, it is simply much more murky, and it is contested in the courts, and we have a split court decision. We have different legal frameworks that govern different states, yet we have an industry that operates across state boundaries. We don't have the kind of authorities that we need, and we don't have the kind of clarity of the legislation that we need as well. I am deeply troubled by what has happened in this case and with NECC, and if there were actions that could have been taken at an earlier time to have prevented it, I would wish that that were so. But, what I'm speaking to now is we have this opportunity. It's a clarion call to action, I think. And if we don't want to see that kind of event repeated, and it's not an event that has occurred in isolation, there have been events in so many members' districts in the past over a period of many years that I think we have an obligation to work together to create new legislation that defines this in a way that is clear and understood and that gives FDA new authorities. Mr. Griffith mentioned, why aren't you writing to compounders, or people telling, why aren't you writing to patients telling that they might be getting drugs from compounders? Well, we don't even know the universe of compounders and what they're making. So we clearly need additional authorities in order to achieve some of the goals that we've been talking about.
And Doctor, that's why I listed the individual component parts of my legislation, just so it could be clear that you would welcome that authority, and then we could ensure that you can be the true cop on the beat. But I do believe that it is troublesome that in the legal definition of drug manufacturer, the legal definition in the FDA statute, it actually exempts pharmacies in that definition. So
in some aspects,
the whole area is just rife with ambiguity. And in that atmosphere of ambiguity, we've wound up with a mess on our hands. And we just have to make sure that that never happens again. Mr. Chairman, I thank you so much.
Thank you. And I would say to the panel, we've completed our questions here. And as the chairman, I have usually the ability to say the last few words. And in defense of Mr. Markey, who made the case in his words as murky, I go back to what Mr. Waxman said, that he was chairman of the FDA. He would not have been cautious. He would have been siding on safety and gone through an exercise regardless of what the situation. I agree with him, and that's why I think he probably should consider being the commission chairman. And also I would say to you, if Pfizer or Merck or any large pharmaceutical company suddenly call themselves a compounding company, you're implying that you wouldn't have jurisdiction over them, when we know that's not true. In fact, when you look historically, you see lots of criminals that are being indicted. They make the case that I was doing work for the FBI undercover. And lo and behold, that was just a front so that they could defend themselves when actually they were committing fraud and criminal activities. And lastly, I would just conclude, Mr. Griffin, Dr. Burgess both mentioned the FDA appears to have the legal authority to walk in and take computers with their jackets. We've seen it on television. And certainly if you had the ability to go in and prosecute and take the computers from NECC, then surely you had the jurisdiction to shut them down because you had the jurisdiction to go in and take their equipment. And certainly I think many of us in this committee are disappointed that you're not providing the emails and information we need so we can get to the bottom of this, and that was the intention of this whole hearing, is to see what really happened. So with that, the subcommittee is adjourned.